to have issue number 3 of my written submissions, my lords. Given the time, I'll just go through the relevant parts of this.
Bear in mind one point, that in 2016, that Maharashtra legislature has repealed the act.
Yes, it is.
It's a question of mandamus to enforce the act.
No, this can't be. That, of course, I bow down to what your ladyship said yesterday. I'm completely bowed down. I'm today now, and as your ladyship said that at the
Briefly, just in 2 minutes, you can point out these two.
yes, my lords, it'll be helpful for me. Just kindly have my note for a minute, my lords. I gave it yesterday, my lords. Yes. Would your lordships be kind enough to just have issue number 3 on page 9?
Mr. Collier, in the soft copy, it is in volume 1 point, soft copy.
My lord, it was a hard copy of my written
It's a hard copy.
Brother Zoe has given hard copy.
Submissions in soft copy is in.
uploaded it in soft copy. We've uploaded, my lords, I'm told. Yes.
Can you indicate the volume?
Huh? Volume 6.2. 6.4. 6.4. My lords, has issue number 3, my lord the Chief Justice.
Just a minute, and we'll also go in soft copy. 4.
My lords, I also gave a spiral bound.
No, not uploaded. No.
They're not uploaded.
All right, we'll go to the hard copy. No problem.
My lords, I'm so sorry. I forgot.
You are going to issue number 3.
3, my lords, on page 9.
Brother Zoe, good. Get a copy. Joy, did you get hard copy? You have hard.
Yes, my lords, I gave one yesterday and a spiral bound today, which has got a. Yes. I'll just very briefly go through the relevant parts, just have my textual analysis, and then I'll straight away deal with Devaru. My lords, has textual analysis in issue number 3?
Yes, 25(1) explicitly.
Yes, Article 25(1) explicitly states that it is subject to other provisions of this part. Article 26 does not contain any such clause. The Constitution already supplies a complete meaning to Article 26 by limiting it to only public order, morality, and health. This is not a case where the provision would be meaningless unless the words were supplied. Morality supplied. To read other provisions of Part 3 into Article 26 would A. Render the difference between 25 and 26 osios, create a false hierarchy of rights even though the Constitution doesn't provide for the same, provide a backdoor entry for other provisions of Part 3 to Article 26, and effect a judicially engineered expansion of state power beyond what the text authorizes. Value analysis. A religious denomination's right presupposes a high threshold of collective identity, organization, and continuity. That is precisely what deserves constitutional protection. This collective autonomy implies the right to exclude certain persons or practices from religious practices. This is necessary to maintain the strength of the religion and ensure that the religion does not lose its identity. As recognized in Shirun Mat, under Article 26b, therefore, a religious denomination or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no authority has any jurisdiction to interfere with their decision in such matters. This is necessary to ensure preservation of the community, bonds that hold the community together as a unit and keep the denomination together as an entity. Therefore, individual Article 25 claims cannot override a denomination's lawful exercise of Article 26b unless one of these 3 heads is engaged. If individual Article 25 claims could routinely override Article 26b, the essence of denominational autonomy would be hollowed out, defeating the constitutional purpose behind Article 26. Now, my lord, straight away to Devaru. My lords, Devaru does not say as a principle of law that 26b is subject to 25(2)b. I just want to read out only one para which I've reproduced in the note. It says 26b is subject to 25(2)b in the specific context of entry into temples. Otherwise, it says that both rights are co-equal of equal strength. In fact, it goes on to say that in all other religious matters, 26b should be given full play, except for the issue of entry into religious temples. And there, in addition, it draws sustenance from Article 17, read with the express words used in 25(2)b as to opening of the temples. So kindly have, my lords, my chart which I have given on the next page. Just one para I need to read. Kindly have para A. chart our submission A, the decision in Devaru must firstly be limited to the facts of its case and understood in that context to throwing open Hindu public temples to all sects. And please see what it said. The substantial question of law which arises for decision in this appeal is whether the right of a religious denomination to manage its own affairs in matters of religion guarantees 26B is sufficient to and can be is subject to and can be controlled by a law protected by 25(2)B, throwing open a Hindu public temple to all classes of sections of Hindus. And then kindly have below it issue arguments as they were and the questions as they were summarized, 3 and 4. If it is a denomination temple, are the plaintiffs entitled to exclude all Hindus other than Gaud Saraswat Brahmins from entering into for worship on the ground that it is a matter of religion within the protection of Article 26B of the Constitution? 4. If so, is Section 3 of the Act valid on the ground that it is law protected by Article 25(2)B and that such law prevails against the right conferred by 26B of the Constitution? Now, let's kindly see the next paragraph. What does Devaru say? The result then is that there are two provisions of equal authority, neither of them being subject to the other. The question is how the apparent conflict between them is to be resolved. The rule of construction is well settled, and when there are in an enactment two provisions which cannot be reconciled with each other, they should be so interpreted if possible, effect could be given to both. This is what is known as the rule of harmonious construction. Applying this rule, if the contention of the appellants is to be accepted, then Article 25(2)B will become wholly nugatory in its application to denominational temples. Though, as stated above, the language of that article includes them. On the other hand, if the contention of the respondents is accepted, then full effect can be given to Article 26B in all matters of religion, subject only to this, that as regards one aspect of them, entry into a temple for worship, the rights declared under Article 25(2)B will prevail. While in the former case, Article 25(2)B will be put wholly out of operation, in the latter, effect can be given to both that provision and Article 26B. We must accordingly hold that 26B must be read subject to Article 25(2)B. So, my lords, my respectful submission is that even Devaru said it's not about one being subject to the other, it's about harmonious construction. And in all matters of religion ordinarily, 26B will have its full flow, except for on the question of entry into temples, which would otherwise render the interpretation of 25(2)B nugatory. Now, my lords, when
Even on the touchstone of public order, morality and health, if a legislation is made under 25(2)B, you can't say that the right of the religious denomination will still prevail. Ultimately, it is subject to public order, morality, and health. That could be the basis for a social reform.
I
or a
cannot
social welfare
cannot
legislation
put it
under
better.
25(2).
I completely agree. In fact, when the Constitution Assembly debates were on, and the original Article 20, which is now Article 26, the words public order, health, and morality were not there. When this discussion came up, Dr. Ambedkar said, yes, we are introducing them into Article 26, and the state can regulate on these three grounds. So, to take from where my lady left the point, that when state regulates under 25(2)B, it regulates a right of the denomination, keeping in mind public health, public order, health, and morality. But it can't say that I will reform a religion or a denomination out of existence, as Sardar Saidna said, using something which is not a limitation or restriction provided under 26 at all. After all, there was a conscious departure when 26, and I'll deal with separately, why were other parts subject to to part 3, not there in 26? Wherever the legislature or the framers of the Constitution wanted to provide the regulation in any form, they provided that. To read into social reform grounds which are not provided in the Constitution are actually altering the textual basis. And it's not if those words, if they're read as they are. don't lead to a meaning. There's a conscious reason by what is provided where it is provided. Now, my lords, my second point for your lordship's kind consideration is kindly come to issue number 4 on the issue of constitutional morality, which is on page 13, my lords. Page 14. Page 14, my lords. This, my lords, I would like to read out to your lordships because I have culled out some important issues here. My lords, has constitutional morality does not form part of
Yes.
morality? Constitutional morality is a concept that requires basic adherence to the provisions and norms of the Constitution. It requires adherence to the Constitution core values of liberty, equality, fraternity, and pluralism, and demands that courts and the state uphold these values even against the contrary popular or social morality. In fact, even the Constitutional Assembly debate, there is only one specific area wherein phrase concept constitutional morality has been referred. This exchange was in the context of incorporation of the extensive provisions regarding the administration into the Constitution from the Government of India Act 1935. In this context, Dr. Ambedkar referred to constitutional morality. The relevance of the said concept was also in the narrow sphere of administrative provisions. Importantly, this was not in the context of morality or fundamental right to religion of an individual or a religious denomination under 25 and 26. Therefore, any attempt to seek inclusion of constitutional morality within the definition of morality does not find any basis in the Constitution and Assembly debates. We contend that constitutional morality does not form part of morality because, then on the left side first, constitutional morality has consistently been applied only in relation to state power and issues that affect all citizens. It has not been used to decide cases about religious or religious practices. Then on the right side, in the Constituent Assembly debate, Dr. Ambedkar invoked constitutional morality only once, and that too to defend the inclusion of detailed administrative provisions and to emphasize a paramount reverence for the forms of the Constitution in the exercise of public power. The entire exchange is about preventing the perversion of the Constitution through the mode of administration. It was nothing to do with defining what counts as moral or immoral religious practice under 25 and 26. That same understanding carries forward in this court's jurisprudence. Constitutional morality is used in the context of ministerial appointments to structure the relationship between lieutenant governor and elected government and to test general criminal laws against the guarantees of equality, dignity, and privacy. In each of these cases, the doctrine operates as a lens for judging state conduct and secular legislation that applies to all citizens, regardless of faith. Religion and the validity of a particular religious practice are simply not the subject matter. Note, by contrast, only in Indian Lawyers Association, Sabarimala did Justice Deepak Mishra and Justice Chandrachud's opinion extended constitutional morality directly to give content to the word morality in 25 and 26. Thus, both the Constituent Assembly history and the Supreme Court's own decision show that constitutional morality has from the very beginning been a lens for judging the conduct of the state and its institutions and the constitutionality of laws that apply to all, rather than a built-in component of morality under 25 and 26. Accordingly, while constitutional morality is a possible tool of interpretation and assessment, its field of operation has been confined to governance, institutional functioning, and universal civil rights. Constitutional morality operates as a check on the state's exercise of power, not as a direct restriction on individual rights. The state cannot justify its actions merely by pointing to formal compliance with the constitutional text. It must also demonstrate fidelity to the underlying moral principles of the Constitution, which secure and broaden fundamental rights. In this sense, morality in Article 25 and 26 and constitutional morality work on different planes and apply to different actors. They ought not to be conflated. It follows that constitutional morality cannot simply be read into morality in Articles 25 and 26 as additional freestanding restriction on religious freedom. Any such move would transform a doctrine designated to judge state power into a roving commission to reshape religious practices. To now treat it as embedded within morality in Article 25 and 26 would shift it into an entirely different terrain, scrutinizing the internal doctrines and observance of a faith, which neither the Constituent Assembly nor the prior line of decisions ever contemplated. Second, if constitutional morality were treated as morality in Article 25 and 26, Article 26 would effectively become subject to other fundamental rights. Contrary to constitutional texts, the doctrine cannot be used to expand the grounds on which these rights may be restricted. Then the right. The Constitution draws a deliberate distinction between Article 25 and 26. Article 25(1) is expressly subject to public order, morality, and health, and the other provisions of this part, while 26 is subject only to public order, morality, and health, and is not subject to other fundamental rights under Part 3. If morality in Article 25 and 26 is equated with constitutional morality, that textual boundary is effectively erased. Constitutional morality, by definition, incorporates the entire value set of Part 3 and the preamble. Therefore, treating morality as a constitutional morality would, in effect, import all other fundamental rights as direct limitations on Article 26, even though the framers deliberately chose not to write those words into the provision. The above is exactly the issue flagged by Justice Nariman in his concurring opinion in Sabarimala. And I quote, "The term morality is difficult to define. For the present, suffice it to say that it refers to that which is considered abhorrent to civilized society given the mores of the time by reason of harm caused by way of inter alia, exploitation, or degradation." Then he gives a footnote, my lords. "We were invited by the learned amicus also to read word morality as being constitutional morality, as has been explained in some of our recent judgments. If so read, it cannot be forgotten that this would bring in through the back door the other provisions of Part 3 of the Constitution, which Article 26 is not subject to, in contrast with Article 25(1). In any case, the fundamental right under 26 will have to be balanced with the rights of others contained in Part 3 as a matter of harmonious construction of these rights, as was held in Sri Venkataraman Devaru. But this would only be on a case-to-case basis, without necessarily subjecting the fundamental right under Article 26 to other fundamental rights contained in Part 3. Therefore, morality in Article 25 and 26 cannot be equated with constitutional morality." And then Cedal 6, "Such an interpretation would convert a limited text-based restriction of Article 26 into an open-ended invitation to rewrite denominational rights through Part 3.
Nothing more than this required.
Yes. Now, my lords, the next point where I just wanted to read out the dissent of the next point is, I won't read the whole thing. The next point is, constitutional morality is itself aimed at harmonizing and protecting all fundamental rights. It cannot at the same time serve as a tool to import an additional restriction into 25 and 26. My lords, I'll skip the rest. Kindly come to Justice Malhotra's dissenting opinion.
Yes, that were read to us.
Yes, my lords, can I just, if your lordships permit, just read two paras at the end? 11.6 and 11.5 to 11.8, my lords, has that? "The concept of constitutional morality refers to moral values underpinning the text of the Constitution, which are instructive in ascertaining the true meaning of the Constitution and achieve the objects contemplated therein. Constitutional morality in a pluralistic society and secular polity would reflect that the followers of various sects have the freedom to practice their faith in accordance with the tenets of their religion. It is irrelevant whether the practice is rational or logical. Notions of rationality cannot be invoked in matters of religion by courts." In 11.8, "Equality and non-discrimination are certainly one facet of constitutional morality. However, the concept of equality and non-discrimination in matters of religion cannot be viewed in isolation. Under our constitutional scheme, a balance is required to be struck between the principles of equality and non-discrimination on one hand, and the protection of the cherished liberties of faith, belief, and worship guaranteed by 25 and 26 to persons belonging to all religions in a secular polity on the other hand. Constitutional morality requires the harmonization or balancing of all such rights to ensure that the religious beliefs of none are obliterated or undermined." As Chief Justice Hughes had said, that a dissent is an appeal to the future. I beseech your lordships to consider this laying down the correct law. The last point on this issue, my lords, and I'll just touch on one more issue, is I have also attempted, my lords, on the first page of issue number 4, which is page 13, if your lordships were to have for a minute. My lords has page 13, serial number 2, morality under 25 to 26. My lord, the Chief Justice has that.
Yes, yes.
13 on morality. My lords, there I have attempted to define what we think is morality means, not societal morality, morality from the touchstone of the community. B, my lords, I have at least attempted to draw the 19.2 analogy to say that even in questions of free speech, where decency, obscenity come as an issue, ultimately what is seen? What is seen is the viewership, the readership, the audience into whose hand it goes. It is never seen from the lens of hypersensitive sensibilities of a generic law. It's always seen from the audience which watches or reads. In such a case, morality has to be seen from the lens of the concerned denomination. And my lords, as far as the Nociter resources principle after that is concerned, that is on on page 14, that is on the principle, my lords, that both for public order and health, in repeated judgments, your lordships have said that the threshold, the real harm danger is very high. It can't be any minor danger to public order. It has to be serious. Health has to be serious. The threshold is very high. My only respectful submission on that issue is, my lord, similarly for morality, it can't be just anyone's hypersensitiveness. It has to be something abhorrent to civilized society. It has to be something which cannot be reconciled at all. That is what is morality, where morality and state regulation on the grounds of morality comes in, which is referred to. So the threshold has to be high for it, and from the point of view and the lens of the religion in question. Now, kindly have my lords, issue number 1 for a minute, my lords, on the first page.
Mr. Call,
Yes.
before we move, can you assist as to whether the morality and the word constitutional morality can be read in the particular context and include constitutional morality, because constitutional morality may be a concept which is fluid. Morality per se may be a straitjacket. One cannot be changed, constant for all time. But constitutional morality itself can be a fluid, dynamic idea, read with the context. So even if we insert constitutional morality to this 25 and 26, probably because of the language, even constitutional morality, and looking at the debates in the Constituent Assembly, it can be balanced to say that even constitutional morality would arrive at the same situation, that it has to be different.
My
And it has to be independent.
my respectful submission would
But
be
straight away just reject constitutional morality itself.
My respectful submission, it's a pertinent question that your lordships have put to me. My respectful submission would be twofold. A, my lords, the context, which I respectfully read out, was right through in the context of governance, right through from Government of India debates, etc. It was never ever a limiting principle for interpreting religion under 25 and 26 or the rights which emanate therefrom. Secondly, my lord, one of the dangers is that under constitutional morality, surely all fundamental rights, preamble, and everything else will come in. Now, the
Not
legislature
necessarily, not that is a very, why not?
will come.
Abstract. I mean, the abstract, we are debating
Morality, my lord,
abstract.
is bound to cover all fundamental rights. It pervades the entire constitution. Now, would your lordships, where the framers made a specific departure between 25 and 26, to say that as far as 25 is concerned, it is subject to public order, health, and morality, and part 3, and other provision, part 3, and 26 specifically only has 3. And when Dr. Ambedkar was dealing with this issue, my lord, of these 3 words missing in the draft article, he said, yes, they should be inserted. After that debate, what was inserted was only public order, health, and morality. Subject to part 3 was still not introduced into it. My lord, this was brought to the notice of the framers that Article 20, as it then existed, which is 26, did not include any limitations. The framers, when they debated, said, yes, it ought to be included. but it only included these three, did not include other parts. If constitutional morality is read into morality, then we are bringing in a lot more than was ever envisaged. And would your lordship supplant that meaning and introduce those words when the legislature or the framers?
Now we understand your argument. Your argument is there is no constitutional morality under Article 25 or 26. It's only a spirit of the Constitution. If it does exist, it should endure to the benefit of the persons who are having freedom of religion purpose. Correct?
Yes.
Hold on, we got it.
Yes.
We understood, sir.
Yes.
This morality means the social mores, good social mores.
Yes. And my lord,
What it essentially
my lords,
means.
I was just thinking, reading on it, that I really wonder if any form of abhorrent social, according to me, because that's the real concern. How do we deal with it? Would pretty much be covered between public order, health, and morality. Which abhorrent social evil will not be covered within these limitations?
Understood. On issue number one, Mr. Kaul, these points have already been argued
Manos, this point has been argued, but I just wanted to show.
because 40 minutes is already there.
Manos, can I just?
No, please. We have to close it.
I'm just summing up.
Only argument number 1 and 2 you can read, otherwise we have read it.
Yes. Manos, can I just in this only say, please have, I'll read argument 1, 2, and then 5 and end with it. 5 and 6, I'll end with it, my lord, if your lordships permit me that. Yes. 1, your lordships has on the first page.
That's right.
Article 25 protects a broad, universal, and inviolable right. Article 25 grants to the right to all persons. The right is granted in broad terms, including freedom of conscience and the right to profess, practice, and propagate. This court's judgment in Shirunmat and SP Mittal show that religion also includes the right to exhibit his belief in such outward acts as he thinks proper and to propagate or disseminate his ideas for the edification of others, and includes overt expression in rituals, observances, dress, food, and conduct. Argument 2. If the constitutional right was intended by the framers to be broad, universal, and inviolable, and context-dependent protection, the right ought not to be constricted by virtue of a judicially curated test to merely the essential or integral aspects of religion. No textual basis of essentiality. Neither the text of Article 25 nor Article 26 limits constitutional protection to practices which are essential, integral to religion. The words essential or integral do not occur in 25 and 26. Insufficient judicial expertise to determine essentiality. The question of what is entitled to constitutional protection and constitutes religion is not capable of determination by any objective or straitjacket formula, as religion is heterogeneous. Some systems prescribe diet, dress, temple entry norms. Others reject anthropomorphic deities or rituals. Even essentiality was to be considered what is essential. Therefore, is a theological question determinable only by reference to doctrine, scriptures, and internal understanding of the community itself. Now, your lordships may also skip 3 and 4. Kindly come to 5, my lords. I'd rather read 5 and 6 because that's my lords has 5.
Yeah, finally.
Therefore, the test firstly, it is impermissible to add, modify, or subtract from the specific constitutional text, and accordingly, additional derogation of essentiality as engrafted by some judgments is entirely impermissible. Even if the right under Article 25 is to be restricted to what constitutes the essential practices of religion, the decision on what constitutes an essential part of religion is to be ascertained with reference to the doctrines of that religion itself, by the said religion and not by outside authority, including courts. C. A more workable approach which ensured due deference to the constitutional right can be imposition of a threshold test borrowed from this court's decision in Bijoy Manual. That is, a factual determination of whether religious belief practice is sought to be protected is genuinely and conscientiously held. And then 6, my lords. First, the opinion of Justice Chandrachud, which says there is that your lordships have seen. Justice Indu Malhotra's opinion, your lordships have seen. And my lord, Mr. Sirvai on the next page says that the reference to in the Dargah judgment to superstition was wholly unnecessary. Superstition for one could be the faith for the other. And my lords, that last para on that page, if your lordships were to have ends of that issue, where Mr. Sirvai is quoted, it says, the obiter in Durga committee runs directly counter to the judgment in Shirurmat and substitutes the view of the court for the view of the denomination on what is essentially a matter of religion, the reference to superstitious practices is singularly unfortunate, for what is superstition to one section of the public may be a matter of fundamental belief to another. And lastly, issue number 2, if your lordship were to have for a minute.
That you have already.
I
said
just
that
wanted to
you
show
will
one
not
thing.
clear that.
I just wanted to show Dr. Ambedkar's one line. Please just have serial number 4. My lord, just serial number 4 on it. Serial number
That has been read
No, my lords, what
7 December 48.
I just wanted to read one thing. Please have on 7th, the third point, on 7 December 1948, an amendment was moved to introduce these limitations by Dr. Ambedkar as follows. Sir, I move that in the beginning of Article 20, the words subject to public order, morality, and health be inserted. Then, sir, it was just an omission. Honorable members will see that these words also govern Article 19. As a matter of fact, they should also have governed Article 20 because it is not the purpose to give absolute rights in these matters relating to religion. The state may reserve to itself the right to regulate all these institutions and their affairs whenever public order, morality, or health require it. But there's 2 points low. They were showed that under 25, it is there and it's missed out here. But 25 had subject to part 3 also. Still only these 3 were inserted. Secondly, what fell from my lady, even if a regulation comes or a state regulation comes, Dr. Ambedkar recognizes it to say that it has to be within the contours of the 3 grounds provided therein. My lords, I will lastly end by saying, my lords, there's an article which I couldn't get it circulated. I'll have it circulated to your lordships, my lord. It's a very interesting article.
You can give us, we'll,
Written by Mr. Shashi Tharoor in the Indian Express. And I'll just 2 lines, there are some significance. It makes very good reading, my lords. I'll just read out 2 lines which makes this, that when the gavel falls on matters of deep-seated belief, it must do so with an awareness of the limitations of legal logic. And then it goes on to say, my lords, that when the judiciary attempts to reform a religion by stripping away the specificity
Where are you reading?
that define it. Manoj, I haven't given it. I'll be circulating it. I'm just reading out. I just circulated. Manoj, I read this and it came to my knowledge today. So I just got 1 copy. I'll get it circulated. It says when the judiciary attempts to reform a religion by stripping away the specificities of that define it, it risks becoming an instrument of alienation rather than enlightenment.
so call, we respect all eminent persons, authors, scholars, juries.
No, Manoj,
But
these are just views.
sometimes personal opinions are personal opinions.
Manoj, that's all right. But Manoj, there is never any harm in all humility, I submit. If knowledge and wisdom comes from any source,
Yes, yes,
any country,
No
any
doubt.
university, it should be welcome, my lords.
no doubt.
We have far rich jurisprudence not to
Learn
accept
from others, no
all
doubt.
forms of knowledge and information that come in, my lord.
But not
Thank
from WhatsApp University.
Not from WhatsApp University. No matter, I'm not getting into it. I just thought at some stage we were getting into which university and author is good and bad. That's inconsequential in this debate. The question is, from wherever knowledge and information comes, must be accepted, not slavishly, but to consider and arrive at a just and
That is
reasonable
what the
decision.
Vedas say. Let
First
noble
stanza of Rig Veda is that Ano
noble
Bhadra
thoughts
Tutuvo
come to us from
Yantushvataha.
all sides.
Absolutely. That's
Let noble thoughts come to us from all angles.
absolutely, my lords. And we are rich enough and strong enough to accept it. Why should
Thank
we
you,
not?
thank you very much.
My lords, I'm extremely grateful for the indulgence.
Thank you
And
very
if your lordships call upon me at any stage on the issue of maintainability,
Yes,
later,
yes.
I would be here to assist your lordships on that petition.
We will request you to assist.
Very, very
The
grateful.
please see the 2016 Act which has repealed it. Please place that on record.
Yes, my lord. Yes, yes.
Of the Maharashtra legislature which has.
If it is not on record, then please place it. Yes, Mr. Radhakrishnan. 5 minutes. Sir, with 5 minutes.
Minutes. I may take around 10 minutes because
Split.
I cannot go beyond that. There is a medical issue also for me. That's why I may have to restrict myself.
Please speak into the mic.
May it please your lordships. I'll be very precise. And I go by the Sanskrit adage, midam ja saram ja vajauti vakmida. That's it. Now, let's, insofar as this matter is concerned, unity in diversity is a hallmark of this multilingual and the multi-religious secular society. Now, our constitution does not envisage unbridled right and uncanalized freedom. And insofar as 25(1) is concerned,
You have given your notes here.
beg your lordship,
Arguments are given.
Yes.
Arguments are given to you.
Yes, yes.
Written arguments are given by you.
I have submitted my written submissions
Where
at,
Volume
with
1.1.
on page number 145.
But you're only summarizing it.
That's only a summary. I can.
Volume, which volume?
1.1.
1.1. 1.1, 1.4.
1.1 minutes, page 145. 145, Hannah. Minutes, I should have submitted. I am appearing on behalf of a senior member of the Pandalam Palace, and he is the foster father of Lord Sri Ayyappa. I should make that submission. I should have made that submission first. Now, Lordship may kindly see, there is a fourfold restrictions in 25(1). This purpose of these restrictions to my mind, because yesterday Sri Rakesh Dwivedi gave a historical perception to this. And the purpose I may summarize in 2 words. It is for the purpose of securing peaceful coexistence in this nation. That is from the history. If you are taking the area of 1945 to 1949 or 1950, what had happened in this country. So it is to nurture secularism and peaceful coexistence in this nation. These fourfold restrictions are provided in Article 25(1) is my most humble submission. Now kindly see, minutes, these fourfold restrictions. Number 1 is public order. Lordship may kindly see in the judgment rendered by my Lord Justice Hidayatullah in 1966, AR 1966, in Ram Manohar Lohia case, His Lordship has drawn in paragraph 52 3 concentric circles. And that first concentric circle is with respect to security of the nation. The second concentric outer layer, that is with respect to public order. The third concentric layer, that is with the law and order. Now, with this, with the right to have freedom of religion and with the right to have conscience, freedom of conscience, you cannot tinker with the second concentric circle or affect the cause anything that will affect the tranquility of the society. This is number 1, public order. Now the number 2, minutes, is morality. That is maximum number of good that you can procure, that a human being can procure. This is how Jeremy Bentham, in his theory of legislation, speaks about morality. Now, in our constitution, only the word morality is used in 25 and in 26 and in 1905 and 6. And in 1905 and 6, there is a collocation of words that is in the interest of general public. This is very crucial. And this can be connected to the peaceful coexistence of the people in the society. 1901, all the rights provided in 1901, especially D, E, and G. When your lordships are taking 1905 and 1906, the collocation is used, reasonable restriction is imposed in the interest of public. Likewise also, in 25(1), in the interest of public comes in with morality. And morality in Indian Constitution, there is no prefix. That is, it is used as such in 19 and 25 and 26. Now, you can call morality as a generic term, and 4 species can be identified. The 4 species are public, individual, constitutional, and institutional. And these species, I'm sorry, these species are only smiling at each other. I'm asking a question, why? Because at the bottom of this, there is righteousness, fairness, justness, and to borrow the word from Hindi, nyay. This runs through 14 to 17. So why should one be afraid of constitutional morality? Because it is on righteousness, fairness, justness. There cannot be any arbitrary action. Then your lordship will pull down the noble golden weapon under Article 14. Constitutional courts will definitely pull down, apply the same. It is just like the Sudarshan Chakra of Lord Mahavishnu. When it is taken out, it will definitely strike, which your lordships are performing under Article 2. Constitutional courts are performing, is my most humble submission. Now, I may respectfully submit that Article 14 is a noble golden weapon in our Constitution, in the hands of the constitutional courts. Now, Lordship, may I kindly see, the next point is with respect to health. Insofar as health is concerned, I may bring to your Lordship's kind notice, during the COVID season, this Honorable Court took notice of the alarming newspaper report, and a suo motu, writ petition number 5, was registered by His Lordship Justice Nariman and Justice Gawai. COVID Kanwar Yatra from UP to Haridwar. Now, whether it will spread. In Constitution, the schedule, it is the duty of the central government and state governments to see that this is not spread, contagious diseases. So I also was in Cochin at the time. I filed an impleading application by myself as a party in person, which was admitted, and the contention raised were appreciated. And the CSV senior, as well as the learned solicitor, rise to the occasion, and they persuaded UP government to take appropriate action to see that the Kanwar Yatra was not taken up. It never displeased Lord Shiva, never displeased Lord Mahavishnu. This was the position at that time. This is with respect to the health. Now, other provisions of the Constitution I have already submitted, about 19 as well as about 14. Now, Lordship, may kindly see conscience, the next word in 25(1). Kindly apply the rules of arithmetic. 4 plus 4 is 8. Now, some persons may feel that 4 plus 4 is 9. And those people, 4 plus 4, 9, are problematic and enigmatic, is my humble submission. They may tinker with the second circle, public order. They may go against the principles of morality. They will challenge it. As they have challenged in the writ petition, they have derided Lord Sri Ayyappa, denigrated Lord Sri Ayyappa. And somebody recently challenged the noble holy Pope also. I place them in the group of 9. They can be problematic. This is about conscience matters. And with respect to religion, it is a means to extricate people from the trials and tribulations of the life. And moreover, it realizes the Purusharthas, that is 4-1 Dharma, Artha, Kama, and Moksha. And in Tamil, it is called Aram, Porul, Inbam, and Vidu. So religion helps us to understand what is Purusharthas. God has bestowed with the human beings with intelligence. And with a very intelligence, we are violating the code. And in fourfold manner, we are committing Papa every day. Man is liable to prone to
Radhakrishnan, please-
Number one by,
Please confine to the case.
beg your pardon.
We appreciate your edition in philosophy and other things, but please restrict
I
yourself to
I
the
shall
case.
proceed, Minister.
Yes.
I'm sorry, and I shall proceed further.
Yes,
Now, to extricate ourselves, to cleanse ourselves, the Vrata is there. 41 days Vrata in Sabarimala, and 40 days Vrata for so far as Christians are concerned, and 30 days Vrata for Islam, dawn to dusk Vrata, and they are doing the 5 namas, and they are doing the Hajj. So these are all activities in our society to cleanse ourselves. Yada viniyatam jittam atmanyevavadishtade nuspraga sarva kamepyo yukta ityuchade tada. This is what Lord Krishna has said. That is the mindset of the devotees. The mindset, irrespective of any religion, whether it is Christian, Islam, or Sikh, or Hindu. And Lordship may kindly see thereafter. 25 2A and B. Now, when you come to 25 2A and B, there is a clear dichotomy that is discernible. They can, in A, economic and all those things, they can regulate, and with respect to other secular aspects of religious practice. So, and the word use is may regulate. Secular, there can be non-secular, there will be non-secular aspects of religious practice. And there is an implied bar or embargo insofar as the state is concerned to frame any law with respect to, that's a secular, non-secular activities of religious practice. And with respect to social welfare and reform, my lords may kindly see, I may add, because my Lord Justice Amanullah was asking repeatedly, probing repeatedly, as to why not sex be there. Now, if your lordships are seeing this particular article, this is my humble submission. My lords may kindly see. May be associated, sections of Hindus, a public character to all sections and sections of Hindus. This is the collocation used there. All sections of Hindus will definitely include men and women. You cannot say that Hindus will include only men. Men and women are there. So women of the lower strata, the alleged lower strata, because I don't consider there is any upper strata or lower strata so far as human beings are concerned. That is my righteousness, approach to life. So these people, the women also are being emancipated. They are also being uplifted. That is the essence. So I am adding, along with 17, 15 as well. My lords may kindly consider. This is my humble submission with respect to that. And I may also tell your lordships how Lord Krishna in Udupi temple, in Udupi, near Mangalore, in Karnataka, one gentleman in 16th century, he was from the lower strata of society. He was not allowed by the priest to enter in the temple. Praise the Lord. Then this gentleman, Kanagadas, went behind the temple on the western side of the temple because Lord was facing on the eastern idol. Western side of the temple, and he sung a song in praise of the Lord. What is happening? A hole was made on the Devaru by the Lord on the western side. And the Kanagadas was given the darshan. Even now, the Lord is on the western side, seeing the western side. This is how justice was done to the so-called downtrodden by Lord Krishna. And now they have made it gold-plated, and that door is still there. Now, I may take your lordships to, I may move on and get to 26.
From east to west.
is connected with 25. I respectfully submit that 25.1 and Article 26, there is a bridging. 25.2 A and B cannot in any way control Article 26, is my humble submission. Bridging is there from 25.1 to 26. And 26 A, B, C, D have to be read holistically. And when you consider morality matters, there is an aspect of public policy also, which means that as per public policy, you are not acting anything against the society at large. So morality and public policy are connected, is my humble submission. So 26B will not be affected or controlled by neither by 26 2A and B is my humble submission, but 25 2A as well. So this is about 25 and 26. And with respect to judicial review of your lordships, judicial review cannot be questioned by anybody. And whenever situations warrant, my lords will be conducting a judicial review. And insofar, lordship will be very reluctant to enter into the ecclesiastical jurisdiction to ascertain, because my Lord Justice Sundaresh was asking previously, when the court can interfere, when the court will be interfere in these nature of disputes. My lords will be very slow. My lords will be extremely reluctant also, because the discretion is there with your lordships, whether to interfere or not. And the plenary power is with your lordships. The inherent power is with your lordships. Just like the COVID, your lordships interfered. Lordships, even on a paper report, whether the practice is abhorrent, if the practice is horrendous, then your lordships will definitely interfere. This is my humble submission with respect to that area. And now, minutes, I may have to go to. I have covered the essential practice area also.
With that, you have covered everything. You already created the bridge. Now we got, we know, how the bridge you already laid one by others, you have cemented it nicely. So we thought you have completed it now.
I will immediately I'll be completing this. With respect to Sabarimala writ petition, I may have to submit.
Yes.
They have not pleaded any prejudice. They are practically non-believers. No, I may have to tell something about this. There was a litigation in the Kerala High Court with respect to Magara Jyoti. That was that Magara Jyoti will be darshan after immediately after Deeparadhana on Magara Vilak. Magara Jyoti can be seen on the eastern side of the temple. Bhaktas will be waiting for that to see the Magara Jyoti and get blessed. Now, a Yuktivadi Sangam, that means non-believers, filed a writ petition before the Kerala High Court in 2011. I'm just bringing to your lordship that. And pleaded that there should be an inquiry into this. This is man-made and all those things. Now, the state government, this is what is to be noted. The state government took a firm stand in the judgment paragraph number 10 that these are all relating to religious aspects, faith, worship, etc. So no need to conduct any inquiry. Why they are not taking the stand in this repetition also? They are saying that this should be referred to Pandits. I wonder, brothers, any Pandits of this contemporary area can sit in judgment over Parashurama, who has devised the Puja Vidhi in Sabarimala. And any Pandit can sit in judgment over Adi Shankara, who has devised in Guruvayur the Puja Vidhi. And on the northern side of Guruvayur temple, a square is there. When you walk around the temple, that square is the place where Adi Shankara landed in Guruvayur and devised the Puja Vidhi. Now, Moving ahead, I may respectfully submit. If you are seeing the paragraph number 3 and 5 of the writ petition, all sorts of denigration, deriding remarks about Lord Ayyappa. Divine baby, no, they are not believing. Scurrilous remarks, if I may say so, and scurrility, thy name is the writ petition. This is my humble submission. And the state government is the trustee, the board is the administrator. These are all slanderous remarks, libelous, Limitation Act. These are all torts. No action. 499, defamation. No action by the state government. The child, this is an infant, the minor, Lord Ayyappa. No action was taken. Even now it is continuing.
Don't go into all those things. Please confine yourself to the 7 issues framed. Please. Again, we are telling you because we are already running short of the time. Other Chief Justice has already informed all the senior lawyers that today we are going to conclude. You are getting into the space time. We are going to give it to the all young lawyers also. Please appreciate it. We understand your argument. Maybe you can reserve it subject to this when review is taken up.
Let's-
Subject to what we are going to. Please.
I think I am not annoying your lordships.
Yeah,
by
we
my
not
submission.
question of honor. We are willing to hear, no problem, any number of days. But
Because
you have to really appreciate, that.
being a devotee by myself, may I just
We
respond?
understand this.
Being a devotee myself, our sentiments are also wounded for the non-action by the state government. I'm only saying that it's a continuing offense even now to Section 22 of the Limitation Act. And no action by the board as well as this. Now, kindly see, they are denigrating the Acharas of Sabarimala also. If you are seeing the writ petition, I'm stopping at that. And my ladyship was mentioning about the divine, my ladyship was mentioning about the constitutional guarantee. Now I am submitting that there is a divine guarantee also in the Gita, that is, yada yada hi dharmasya glanirvavati bharata abhyudhana adharmasya tadalpanam sajamyaham. This divine guarantee I am juxtaposing with the constitutional guarantee. At this note, I conclude my submission. I hope I have not taken or I have not annoyed my lords.
Not.
No, I wanted to be within the limits only. Grateful to your lordships, deeply grateful.
Thank you, sir. Mr. Guru, give log.
Minutes, I am appearing in point 44. They are the female devotees of Lord Ayyappa supporting the existing practice. Only for the sake of introduction, my lord, nothing to do with the argument of this case. I have given additional written submission, my lords. Will also may take these submissions as my submissions now, my lords, not the main submissions. My lords, yes, sir. May I invite your lordship's attention to page number 2, state away issue-wise submissions, my lords. I'm not going to history of the case, my lords, or history of the legislation, parliament debates, nothing. Everything is already covered. The best of my ability, I try to address, my lords, the query and the debate which happened in this court regarding this issue. My lords, the first point is issue number 1, page number 2. Let's got it, my lords, hard copy.
Yes, sir.
The question arose, my lords, is there is a conflicting interest between the two individuals in exercising right under Article 25(1) as well as his right qua 26, the community. That's the first point I try to address. The conflict between the two individuals, my Lord Justice Bakshi pointed out, what is the rights of the dissenter? How he is going to exercise. Kindly similar paragraph 1, I give what is profess, what is practice, what is propagate. Now let's kindly come to paragraph 2. Hoffeldian theory of fundamental jural relations treats the rights and duties as a correlatives, meaning that every fundamental right owed to a person imposes a corresponding duty on others not to infringe that right. An individual right to profess and practice according to their conscience includes the right to disagree with the existing beliefs or practices. However, the exercise of this right cannot be allowed to question the rationality of another belief, faith, and religious practices through the courts of law. They may agree with me, they may not agree with me. They cannot go to the court and saying that let this practice is irrational or this practice is bad. That is the first principle. There's a duty cast on the every individual to protect and respect the rights of the other person at the same. The Constitution did not freeze religious beliefs or practices as existing on the day of its adoption. New thinking and beliefs may give a birth to a new philosophy or even a religion, and those religious practices are also protected under Articles 25, 26. Taking for the moment, my lords, it's not necessary I have to prove 100 years practice or 1000 years practice. That is not contemplated in the Constitution. If today I may come out with a new idea, new philosophy, that philosophy may turn into a practice. There will be a followers that can be tested by your lordship on the basis of the belief of that particular group, not whether it existed 1000 years back or not. So if that is the condition, it should be existed the oldest one, and it has to be practiced for longest period. We went out of Buddhism, Jainism, Sikhism. The Constitution did not stop that. It will flourish. In India, it will flourish. However, a person dissents with a set of existing religious practice does not have the right to join the same without the first adhering to the principles connected to those practices and rituals. Any claim to a right to alter the existing religious practice as per such a dissenter's thought or desire will violate the rights of others protected under the very same articles. Next is Sabarimala. I'm not touching it. Every paragraph, I'm adding how it's connected to Sabarimala. I'm not touching that. Let's say straight away going to the point 2. Well, issue number 2 and issue number 3, I combined it, my lords, and put it in the 3 headings. Well, the first one is, my lords, Article 25(1), conflict with Article 26(b) or 26. My lords, this is my submission, my lords, would be a structural primacy of Article 26 over individual rights under Article 35(1). My lords, what I wanted to say, my lords, any conflict, this is your lordship have seen historical fact, how this 26 and how 25(b) is coined. Well, when there is no subject to call, the subject to the part of this constitution is not mentioned, taking into entire structure of this Article 26, if there is any conflict between 25(1) and 26(b), 26(b) should prevail. That is what the structure. That's why I may say, let's kindly see in the paragraph 3, after extracting paragraph 5, 6, 7, kindly see paragraph 8. Thus, if there is a conflict between an individual rights under Article 25(1) and rights of the community or a group, I'm borrowing a word group here. Religious denomination is mentioned it's not mentioned as a group, but your lordship issue, when your lordships are framing other than the religious denomination or group, that is a conscious inclusion of the words to expand and wider the scope of the Article 26. So I am using the word of group, my lords, here, borrowed from your lordships. Under Article 26(b), then the latter right must prevail over the former. Thus, an individual petitioner's right under Article 25 to enter into Sabarimala temple must yield to the right of the community of Lord Ayyappa devotees under Article 26(b) to maintain the religious condition of their worship. Second, well, these are 2 parts. What happened in this case is religious denomination. Lord Ayyappa was not, association was not treated as a religious denomination. So the threshold they have been thrown out. Once it's not a religious denomination, there is no question of exercising right under Article 26. So I have to deal 2 things in this case. One is the conflict between 25(2) versus 26, and whether what is the how to determine the religious denomination. So first I deal, my lords, 25 and 25. 25(2) and 26. Article 26 is not subject to any other provisions of Part 3 Constitution. It is a standalone article. There may be instances, my lords, I differ from number of senior counsels appearing this side. There may be instances, however, where a law made under Article 25(2) to conflicts with the rights guaranteed to a religious denomination or section thereof under Article 26 Constitution. It may infringe, it may invade. Article 25.2 is the only enabling provision and does not confer any right to an individual. Article 25.2a is a general provision applicable to all religions, while Article 25.2b contains two parts. Part A, a general provision on a power of state to make law providing for social welfare or reform applicable to all religions. B, a special provision on power of the state to make laws throwing open Hindu religious institution of public character to all classes and sections of Hindus, applicable to Hindus only. Article 26b is a general provision governing the rights of all religions and religious denominations, sections, groups, and organizations. So we have a one general, though it is a special right, general provisions covering all the organizations, all the communities, all the groups under 26. We have a equally, we have a 25.2b. I'm not reading 25.2 as a subject to. 25.1 is subject to. 25.2 is a standalone provision according to my submission. It's standalone provisions. So the standalone provisions have two parts. One is for specifically Hindus, one is for general. So now we have two independent standalone constitutional provisions. That is where the difficulty comes, my lords, when these conflicting with each other, then your lordship have to decide.
Please tell us whom does it apply to? 26.2b applies to whom? Let us find out from you.
26.2b applicable to, my lords, all religions in first part.
First part speaks about persons. So it applies to all persons, persons of conscience, belief, practice,
Yes, yes,
propagate.
Yes, my lords.
So it will apply to all the persons,
Yes, my lords.
but it will not apply to the denomination, to the.
I say apply.
You are saying, see, the standalone provision means what does it mean?
Well, standalone provision is, my lord, that's why I'm
I
there.
am trying to tell you, when you make a submission, you should try to make legally sustainable in the sense. If you say, if 100 people join together and create a religious denomination, if you accept the argument, under 25.1 they have a right, 25.2 it can be regulated, but it can't be regulated to the, it's only as.
No, I'm saying it will be regulated. I'm coming there. That's what I'm saying. Well, that's what I say standalone means the right is standalone. It can be a standalone two rights in two different constitutional parts. Well, it's minority rights. It's a standalone, but it may come under the other provisions to regulate it. So standalone in the means, I'm not telling the lordship that you can't touch it. No, not in that sense. I'm sorry. I might have wrongly conveyed it. Standalone is a standalone rights conferred. Next, I'm saying that's how it conflict comes. Kindly see, 25.2b will law made under 25.2b will definitely infringe the rights of 26.
I think we are not made of it clear. This conflict you are saying, see now, according to you, there's a conflict between 26 and 25, correct?
No,
There
law
may be-
made under the 25.2b may infringe the rights under 26.
That's correct.
Correct, my lord?
Then the problem will be, how do you give effect to?
That's
If you-
what I'm reading next paragraph. My lords. That may be lordship may
Yes,
highlight.
yes.
Article 25.2 functions as an exception to Article 25.1. In that law made under Article 25.2a or b may also interfere with the fundamental rights of the religions, religious denominations, sections, group, or organization under Article 26. The validity of the law made under Article 25.2 will be tested on the touchstone of the fundamental rights guaranteed under Articles in Part 3 of the Constitution, including Article 26. The test of reasonableness, arbitrariness, discrimination, and proportionality will apply. This is, we can't have a watertight compartment. This is where your lordship, the power comes into that, when their challenge comes to your lordships. This honorable consistently and correctly upheld abolition of hereditary trustees and archagas and condemned the discrimination solely based on birth. I'm taking a moment for here. This is claimed as a religious practice. This for the particular group who asserted it. But your lordship look into that. Your lordship can do two ways. One, your lordship say it is not a religious practice. It is a non-religious practice. Your lordship can uphold the law, or your lordship can uphold the law on the basis of 25.2 saying social reform. So this both aspects your lordship are exercising. So that is what they done. So 25.2b can definitely, when law is made under the parameter, it will conflict. If the conflict comes, your lordship will adjudicate. That's what I wanted to say. So I'm not saying that you can't make a law, you don't have a power. I'm sorry if I wrongly conveyed it. Since the state has the power to make the laws under Article 25.2, curtailing or interfering with the fundamental rights guaranteed under Article 25.1 and Article 26, the said power cannot be used to the extent of nullifying or destroying the fundamental rights guaranteed under Article 25(1) and Article 26(b) and make those rights odious. This is the one submission. Let's borrowing the word from Muller's Saidan judgment. Let's kindly see what the court said. In my view, by the phrase laws providing for a social welfare and reform, it was not intended to enable the legislature to reform a religion out of its existence or identity. Dismantling the specific condition or practice of worship in a particular shrine under the guise of social reform would be akin to misusing Article 25(2)(b) as a tool of religious destruction than the social reform. This is my submission, my lords. When it coming to every facts, case to case basis, your lordship will apply accordingly to the situation. My lord.
Malal, this is already said that.
That's
Prima facie, we.
my lords.
will give-
I'm done with that point. Now, my lords, this is the most important question. My lords, did so religious denomination. My lords, your lordship have been shown how it started with a dictionary meaning, then how it is developed. My lords, it's developed to the extent in the Sabarimala case. I just wanted to read a ratio laid down by your lordships in Sabarimala case. What is a religious denomination? While holding Lord Ayyappa is not a religious denomination, paragraph 96, the lordship's Chief Justice Deepak Mishra has held for a religious denomination. I'm reading words, I'm not wasting your lordship time. For a religious denomination, there must be a new methodology provided for a religion. Mere observance of certain practices, even though for a long time, does not make it a distinct religion on the account. A religious denomination has gone to the extent now I have to give a new religion itself. That is the ratio. Now, tomorrow, if your lordship is not determining this concept, what is religious denomination, this will be cited as a ratio, and all the 99% of Hindu majority will be wiped out. They don't have any right under 26 because they are not a denomination. I will take a lordship why I am saying this point. Kindly come to my third point C. Let's here I gave up how this origin. I'm not wasting your lordship's time. There are 4 constitutions which my learned friends also senior also pointed out. Irish constitution, Polish constitution, Yugoslavia constitution which now doesn't exist because the country has gone. Then Italian constitution on the same year which we adopted uses these words. Polish does not use the word of denomination, but other 3 constitution uses the religious denomination. Plus, all these constitutions used to use this words term only for the purpose of majority, minority in all Christian religion or the religion whole. The problem came to us as we interpreted in the dictionary meaning, this which I gave also. 2 dictionary gives 2 meanings. Dictionary meaning by saying that you should have a separate identity, separate distinguished name, a group which will separate from us. There is no when the Indian constitution was adopted, there is no Hindu religious officially recognized denomination. A religious denomination Hindu came only through your lordship judgment. That means if Hindu religion denomination is not existing on the day, none of the Hindu will get rights under protection under Article 26. So it is required your lordship's interpretation to say religious denomination includes a religion as a whole. Then a section thereof will be interpreted a section in the religion. So vast majority of Hindu religion people who does not belong to a specific denomination. But I have done some research. People call it, I don't know who coined this word. Saivism, Vaishnavism, Shaktism and Smartism. What they did is the Smartism is the people who are not following any other category, they will be brought here. So either your lordship call as the people who are not belonging to any of the ism as a Smartism. So the section in the Smartism will get the right protection under Article 26, or your lordship may kindly to say religious denomination. I'm sorry.
Smartism.
Smartism, else I put it in the kindly see my notes. I think SG also put that word. I also searched it, I got it, else I referred it by paragraph. Page 6, my lords, I refer it. Smartism. Shaktism also not there, that also coined.
Shaktism.
Shaktism. Because if you have a Saivism, if you have Vaishnavism, why can't we have Shaktism? So Shaktism,
So Shaktism, all these women, they go.
yes, Kali,
No, Shakti is the temple in Madurai.
Durga temple.
No, in Madras.
Saktam.
Madras, they wear the red dress.
Adi Parashakti temple. Adi Parashakti, Melmarutra, Adi Parashakti temple. Red saree,
Male Marvatu.
red saree, Melmarutra.
That is a new
New concept, new concept.
new denomination. Male Marvatu. Adi Parashakti.
They're using Smartism.
They wear red dress and go, the women.
And used for Smartism. Smartaism, that's what they're calling, not Smartism, Smartaism. Maybe Smartaism.
No, you can also say Smartas or Smarts.
Smart, because they go everywhere and they get the blessing of all the gods. There is a difficulty. Why I'm
Five, essentially they practice, 5 gods, not only one
Yes,
god.
all the gods.
No, 5.
Brahma,
Vishnu, Shiva,
Vishnu,
Ganesha and
Muruga,
Muruga and Shakti.
Sakti.
But Vaishnavites,
They
only Vishnu.
only Vishnu. Vishnu is the sole superior. No other god. So that's the problem for.
Gopal Subramaniam has said Panchayatana in his text.
No, the problem for us, my lords, why we are before you, lords, for 75 years, the interpretation given for the religious denomination shut the rights of the majority of Hindus. I may say, my lords, for coming from Tamil Nadu and Kerala, 95% do not belong to any denomination, which so-called denomination approved by your lords in this court. So where do we go? I just cited my lords Tolkappiyam. It's in the page number 5.
One way is in the denomination means the temple follows Shaivite worship, Vaishnavite worship or Sri Vaishnavite, at least in South India. They are the practices. Therefore, it is called denomination.
No, it's kindly consider.
Now, if it is a Shaivite type of worship, then the Vaishnavites cannot say that it has to be like a Vaishnavite form of worship. There is a difference in the
Yes,
worship.
yes,
Therefore, that form of worship is protected.
correct.
That
But
has nothing to do with
nothing
that.
to do that.
You should have an organization.
That's my submission.
Not necessary.
Not necessary.
A Hindu is a Hindu. He can go to any temple.
No, that's why I'm telling you, in Tamil Nadu, there is a Kuladevam, that is a family deity, clan deity. Then there is a village god. So they have a unique practice.
Yes.
They won't follow any country or any kind of ism or denomination. Whether they have a right or not under Article 26, that is the question before your lordship. They have every right. 26 does not throw the majority of the people of this country and protect only 10% of the people. So that is how why I'm saying with the pain, that is how entire judgment from 1950, Srirmat started till the Sabarimala went on, and
That is the reason why I put a question to the Senate Council. There may be private denominations also. Maybe it become public character.
yes,
There may be, as rightly said, if each place is, India is such a wonderful country where even at each place is different.
that is the
There may
spirit.
be some family deities, family, some clan, group,
Village god.
community, and village, it will be there.
Devaru.
Yes.
I am coming for a village, we have a village god. The worship is different. We have 3 temples. I'm just giving you for a second example.
Gram Devata.
Ramdev.
Grama Devata.
Devata.
Grama Devata. We have 3 temples, my lord. It's a Vishnu temple.
Yes.
Brahmaniman also said that if religious denomination is to encompass the religion per se,
Local bird.
then the makers would have used the word religion in 26 as in 25(1).
So once you.
Every religion or any section thereof. Instead of doing that,
Only to the member.
they use the word denomination.
Like you have that.
Denomination must be given a distinct and different meaning from religion. If we give a generic meaning, as you are suggesting, that the religion encompasses everyone and it should be treated as a denomination in contradistinction to other religions. If we do that, then we will be giving the same meaning to the word religion in 25(1) and making the two words same, but the makers have used consciously denomination in 26 and religion in 25.1.
May I answer?
So
May I
this
answer
is
it,
something which needs to be
Yes,
interpreted.
that is the debate, Malad, that is required to be considered.
That request.
Malad, kindly consider, Malad, why we can't say that, Malad.
Followed it. We don't, that is, that has.
No, we can't say, Malad, the founders of the constitution have committed a mistake. We can't.
Your submission
Submission.
that it cannot create class within class.
That's correct. That's
That
what I want.
Someone is ascribed with denomination and higher status in a 26B, whereas as you say, a village god or a temple or a group of people having a certain form of worship or practice does not get the protection of 26B. However, the legal interpretation that you are giving of denomination may become problematic because we will be reading an independent expression consciously used by the constitution maker and equating denomination with religion.
But that's why.
That is the.
Well, that's why I gave a suggestion, two things, Malad. Either your lordship read as a religion as a whole, so that everybody will be covered, or your lordship debate a Hindu center denomination, whatever the matter it may be, residuary is a denomination. But that is also a different way of your lordship approaching. But what I wanted to place before your lordship.
See, what you are saying, see,
More relevance in a non-Hindu religion. That's
Yes,
it.
it is meant for non-Hindu religion, which is organized, my lord.
there's no need to go into all those things now. If you understand 25.1, it says about conscience. It doesn't speak about religion, 25.1. So if a common believer having a conscience and then professing it, propagating it, they would form a denomination by themselves. The expansion is much wider than what you are saying. You have, prima facie, I'm in agreement because you have to give effect to the conscience, followed by the belief and practice and professing. That is protected. The intention is to give the flexibility to that group. To that group. Therefore, wider import will not be given on the definition of the denomination, religious denomination under 26, to make it inclusive of all different sects and separate groups, because that's why it says sects thereof. It may emanate, see, maybe a common thing may emanate, but as the cynic also was saying that you can have a faith in particular God, and something go may beyond it also. Something go beyond it, something go under it also. It may partakes different characters. It's a question of we live into the belief and imagination of each one group. It's always, it's how people perceive it. It is their own comprehension. It may be philosophical, maybe other things. Like they said, maybe something beyond. He has also quoted something. In our literature, in Ramayana and in Tamil, I'll tell you, when in the battle, when Rama is facing Ravan, and he was on the process of losing, Ravan asked the question about, and after looking at Rama, he just says, "Who is this guy? Could it be Lord Shiva?
Because
Could it be Lord Brahma? Could it be Lord Vishnu? Or he is the guy who is above all the three? Which means he goes beyond that.
Beyond all.
Could it be that person? It's only, it's only a thought process, but each one will have their own view. We cannot go into that, but you are right. Very difficult to define religious denomination in a particular bracket, because such a country of this nature where we have different faith, philosophy, thinking process. Better these things we should leave it to the believers themselves.
No, I stopped there.
You can also say 26 is in a way an expansion of 25.1.
Very well. That's also a lordship can say. But
Yes.
what troubling my Lord Justice Bakshi is, how do I substitute a word which you are trying to put it when it comes before us tomorrow, whether this organization is a denomination or not? Well, this general discussion is something different from your lordship authoritative writing a judgment to cover which words your lordship are going to use. If your lordship are going to say religious denomination means religion itself, or your lordship are going to say no, some group is sufficient, there is no denomination. This is a really as a challenge. I stop there. I stop there.
We have understood that.
I stop there, my lords. Well, I gave some example in Tolkappiyam how the gods were worshipped in Sangam literature. I'm skipping that all this thing. Well, kindly come to my next point. Well, morality, I'm not touching. It's argued, my lords, constitutional morality is governing principle. I adopt Union of India's argument. Well, second, this is also one of the points which your lordship may consider and authoritative pronouncement may be recurring. Issue number 5. Well, what is the scope and extent of judicial review? Well, here we have two questions, my lords. How your lordship going to test is a practice as a religious practice or expand your narrowed concept of essential or integral religious practice? And with which text your lordship are going to test it? Well, if your lordship are testing a Christianity, you can take a Bible, whether it's point of it, or Quran, lordships can take it and verify it whether it's a religious practice or not. How do we test the Hindu religious practice? Well, I requested to paragraph 28, my lords. So 28, 29, I'm citing, my lords, Tolkappiyam and Tirukural. My lords, Tirukural and Tolkappiyam all are Sangam literature beyond 2000 years. Accepted, my lords, is a manuscript. That's all this don't refer any Vedas. Rig, Ajur, Sama, other one, none of the Vedas have been referred in any Tamil ancient literatures. Are you going to test my practice with the religious Vedic principles? It has to be tested to the believer of the Guru, not as a religion as a whole. Lord Ayyappa's practice was tested as a religious practice of Hindu religion as a whole. That's why it is not a practice, essential practice, needed practice. All this concept came. I request your lordship, looking at the diversity of Hindu religion, when the question comes before your lordship are testing first whether it is a religious practice or not. If it is not a religious practice, you don't have protection there. If it is a religious practice, I request your lordship don't go further to test it whether it's an essential or integral part. And how you lordship are going to test is a religious practice for the principles of the believer of the group, not as a religion as a whole. That submission I am done, my lord, that point.
The essential religious practice, don't take it in the technical sense. As opposed to a secular practice, another practice is essentially religious. That is different from saying essential religious practice.
That's what my lord Chief Justice also pointed.
Essentially
Well, that also.
No, it's not a secular practice.
Sai Deepak is raised this.
Yes.
Well, and another caveat here for here, your lordship test it on the basis of the belief of the particular group, not as a religion, queer religion. So please kindly don't test my practice as a whole Hindu religious philosophy. Well, you have a different beliefs. Belief I have given. Kandapanar in Sri College, just another 2 minutes. Is a person who went to worship a god, Lord Shivalinga. He, my lords, is one among the 63 Nayanmars whose idols are in the all Shiva temples in Tamil Nadu. Nine Mars. I'm sorry. My lords, he went and he is born by a hunter family. He is a hunter. So he got a devotion suddenly on the Shivalinga. His method of worship is he takes the water in mouth to clean the idol. And he served the flesh of the meat which he got it from everyday hunted and put it in before the idol. The pujari who does everyday morning puja, he comes and sees what is happening is they are committing a sin on the god serving a flesh meat before the god. So he was crying. Then one day God said, every day it's happening alternatively. One day he was crying before the god. The god said, wait today and watch. As usual, Kandapa has come. He saw. He wanted to again do a puja, but bringing water in mouth because he is carrying a meat in one hand and his bow and other hand. So he can't carry water in hand. So he was carrying water in mouth. And he does all these things. Then he saw suddenly the bleeding in the eye of the god, lingam. He doesn't know what to do. He was wiping it and everything. This is the temple is there now. He is wiping everything. He is doing it. Still the bleeding is there. So what he did is to his knowledge, whatever comes out of his feeling. He removed his eye, fixed it in the eye of the Lord. Then bleeding stopped. He was very happy. He was praying. He was a real joy. Then suddenly he saw the other eye also bleeding. He doesn't know what to do because he got the idea now. Once you fix the eye, the bleeding will stop. So he has a second eye. He thought to take a second eye. Then he doesn't know how to fix it because if he removes both eyes, he will not be knowing the spot. he put his foot, thumb finger on the eye of the linga, God, and he started to remove the second eye.
Vedara Kannappa. There's a very famous Kannada movie, Vedara Kannappa.
See, the Kalahasti temple, my lord, this is recorded. This is the, if you are going for ethics, I mean, Vedic principles or any mythology, this is also mythology. There, the God came in front of him and gave a moksha. So that is the practice.
So that is devotion.
Devotion with the practice of what he knows, the way how he want to worship. The way I want to worship is according to my choice. Well, it's what I know, the way I will. The medium of connecting a God is according to my choice, my lord.
Understood.
That's all. That's all. Well, let's in the last
But
point.
Mr. Puthuraj, suppose we test it, you said that otherwise all Hindus go out if it is not given that meaning. Why? Suppose you don't want to be called a Hindu, but still you have a practice because worship is part of a religion. Now, if you belong to a community, you may not be identified as a Hindu per se, but if you are governed by the personal laws of Hindu, the marriage laws of Hindu, then automatically you come under the Hindu denomination, and then worship is a facet of religion. You come under the Hindu religion. How are you ousted?
May I explain to my lords?
Are you ousted from
Well, that religious denomination is a sect distinct from the religion, the definition which you also followed and applied.
how it is distinct? It is part because otherwise, broadly you are Hindu.
That's what we want to say. We are part of it. Don't treat to
How
make
do you say that it throws you out? Why is that apprehension?
not apprehension. My lord, this is what happened after the past 75. That's why I was reading my lord's judgment, which again I'm reading for a religious.
Denomination, you don't get the production.
Let's,
I think something more.
well, let's do this right. First, I have to establish I am a religious denomination. Then only I will get into the Article 26 right.
You are because worship is a form of a religion. It's a religious activity. Setting up of a temple, worship, it's a religion.
Correct.
And then when you are part of religion and you broadly come under one, either Islam or Hinduism or Christianity, automatically you come under religious denomination.
Your lordships are
Ousted.
Your lordships are absolutely correct. But when we come to this code, the code says you are not a religious denomination. That's why again I'm reading. Well, this is a your lordships are absolutely. This is what we want. This is what we want. This is what we want. Well, kindly last point, my lord. This is a non-religious, not person belonging non-religious denomination or group. My lord, this is an important question for your lordship, which put it here. Your lordship did not use a non-religious, I mean, a religious denomination. Lordship have used word or group. A group as a valid denomination. If your lordship are grouping us, then we have a right. That's all. Then non-believer, my lord, it's very difficult, my lord. If I believe a Darwin theory, all religious faiths are superstitious. If I accept a Darwin theory, which is acceptable in scientific evolution theory of Darwin, is put to everyone. Every religious belief is according to me, it's an irrational, superstitious, because it's contrary to the faith. So that's not a test. So a non-believer cannot test our belief. If it is my belief, it's my right. So that's that non-believer PL on behalf of non.
Article 25(1) is meant to protect a believer against anybody, including a non-believer. So long as I have a belief, the non-believer cannot come touch me.
He can different of opinion. That's a different thing. I'm very grateful, Miles. I might have taken a little longer time. I'm sorry.
Thank you, Mr. Jain. Thank you very much. Yes, Mr. Rangupta.
Devaru followed Darwin from the fish onwards.
May it please your lordships. My lords, my colleagues, Mr. Krishna Kumar and Mr. Devan have been very kind and allowed me to go ahead, my lords. May I, my lords, hand over my submission, the original submission, which is some length, and a much shorter submission, which also takes advantage, my lords, of the submissions of all my colleagues. I appear, my lords, on behalf of several Jain organizations, which, my lords, have been operating under the guidance of His Holiness Jain Acharya Yug Bhushan Suriji, the 79th successor of Tirthankar Sri Mahavira. The Intivinam Gitar Ganga, my lords, is a religious and spiritual research institute that has operated for 33 years working towards correlating ancient Indian principles with constitutional law. I may add, my lords, for the last so many days, your lordships have been getting a very Hindu perspective. I would respectfully, and of course, there was briefly Mr. Subramaniam spoke on behalf of Parsis, but largely focused on a Hindu perspective. The Dawoodi Bohra issue has also been argued before, my lords, but I am on the general principles, my lords, that should operate. My lords, we are concerned for all religions about increasing instances of state intervention, my lords, in the practice of all religions, whether through legislative or judicial intervention. I've given some examples, my lords, in paragraph 2, the ERP doctrine, of course.
So your soft copy is in which volume?
Volume 2, page 459, my lords. That's the original submission. My lords, I'm taking my lords now through the shorter submission, which has been handed over just now, my lords. Both the original as well as the shorter submission are before my lords now. Volume 1.2, page 459. I'm sorry, I hope my Lord Justice Bagchi has been able to locate it. Yes. Now, my lords, in paragraph 2, I point out various examples of what we're concerned about. A secular state, my lord, ought not to be administering temples and controlling temple management, staffing, and financial decisions. We are particularly concerned, my lords, about compulsory acquisition of sacred sites, which are believed for millennia to be divine and sacred sites of worship by the Jain community. My lords, I may only tell my lords that we are even older than Buddhism. If one looks at Mahavira, who is the 24th Tirthankar, he historically existed in the 8th to 9th century BC. The two previous Tirthankars are also believed to historically exist and probably goes back to about the 14th century BC. So we're a very, very old religion. Although Hinduism predates even Jainism, which I'm not disputing, my lords. Then, my lords, the last is restrictions imposed by the state on how, say, religious funds may be managed or invested, even though our scriptures, my lords, impose specific obligations on trustees regarding preservation and augmentation of religious funds, such as Dev Dravya. I may only add, my lords, Dev Dravya has been recognized in the Ratilal Panachand Constitution Bench decision. It's basically, my lords, where a particular devotee makes contributions to be utilized in a particular manner and no other for the my lords, religion. That is the Jain religion. I represent, my lords, a Shwetambar Jain sect, which is known as the Murti Pujak sect. And just to quickly clarify for your lordships, Ratilal Panachand says we don't believe in God, in the sense only that we don't believe in a creator God. I've taken instructions, my lords. The Tirthankars are supposed to be the perfection, the embodiments of perfection in terms of how they have lived their lives and lived by the Jain ideals, in terms of, my lords, sacrifice, not, my lords, engaging in physical, material pursuits, etc., etc. And when you reach that level of perfection, then you are worshipped, but as the embodiment of perfection. In other words, humans who have attained the status of divinity and therefore are worshipped as gods, not as creator gods, though, and not gods who interfere in human affairs. Then, my lords, I just want to point out one important distinction that I wish to make, a background issue which my lords may kindly keep in mind. What has been articulated till now is a general view that there may be imperfections, there may be problems in the manner in which a religion worships and conducts itself, and the remedy lies in state intervention. I am posing, my lords, the opposite point of view, which is that in fact state intervention in religion, paragraph 3, my lords, has actually resulted in the introduction of politics into religion, which corrupts both the state, my lords, and religion. And therefore, my lords may keep in mind that state intervention is not necessarily the panacea for all ills in a religion. It can come from within the religion itself. And there is, my lords, a trend mentioned in the Constituent Assembly debates that reform ought to come from within religions. And I go on, my lords, to point out that disputes that arise actually ought to be resolved in the sphere of private law by application of principles of trust law. Dr. Dhawan, my lords, has been at pains to elucidate how one can do that. Section 92 of the CPC is available. One can take evidence. There are wide powers, including, my lords, the framing of a scheme. There are remedies, therefore, my lords, in the civil sphere that do not require the passing of a special state law to intervene and take over religious affairs. That's one important submission, my lords, that we are making. Then, my lords, I'm going to skip over the one important point I want to make, my lords, here. Most legitimate state goals, and I think this is what has fallen from my lords as well. Almost all legitimate state goals for intervention in matters of religion can be resolved under the three heads, my lords, which are there in both 25(1) and 26. In many ways, if one examines how Rajkumari Amrit Kaur's views, my lords, on the need to ensure that religion is not given absolute play, if one examines closely the debate, the view was that it can be taken care of under the heads of public order, morality, and health. Morality and health, my lords, really can substitute for social reform under 25(2)(b) in most ways. And I'm therefore respectfully submitting that one can, in fact, construe 26 in a manner where legitimate state intervention can be, will be permissible without resorting to 25(2)(b), which is why Dr. Ambedkar came in and said it was always intended and nothing more is really necessary. So, my lords, legitimate state goals can be achieved under these heads. I believe it fell from my lady, Justice Nagaratna, that in fact social reform can be read as coterminous with morality and public order and health. So I would respectfully submit that's an important way of looking at the matter, which would also be constitutionally permissible in terms of interpretation, my lords. I want to tell my lords that I was present as a young lawyer, my lords, on one side in the Patel engineering case decided by 7 judges, presided over by His Lordship, late Chief Justice Lahuti, where Mr. Nariman came and told the bench that when my lords sit in a bench of this strength, really it is in the nature of a seminar more than an adversarial litigation. Your lordships take on board all points of view and then try to arrive at a proper system of constitutional interpretation. This case is important, my lords, because it will govern the lives of almost 1.5 billion people in the country. But in addition, I want to tell my lords, it will be scrutinized and read by constitutional scholars all over the world to see how our court has dealt with these very vexed issues. I may add also, my lords, for 70 years almost, these precedents which have been quoted before, my lords, cited and quoted, have stood and created, my lords, numerous vexed problems of constitutional adjudication. I would request, my lords, to keep in mind that whatever my lords does here should withstand not only the test of whether it is appropriate for a country of 1.45 billion, but also that it must withstand scrutiny of all constitutional scholars, my lords. So as a matter of logical consistency, I would say, my lords, that 25(1) is an individual right which is subject to these, my lords, restrictions, that is the limitations. 26, on the other hand, my lords, is subject only to 3 restrictions, does not bring in 25, but legitimate state goals can be met by legislation under public order, morality, and health. That's the submission that I'm making, my lords. And therefore, now, on a fallback, my lords, I say, assume for the sake of argument that 25(2) applies to even religious denominations as well as religions. And I will come back to the question posed by my lord about religions versus the distinction between religion and denominations. But for the time being, I just want to say that the essential practices test has no textual foundation whatsoever in Article 25(2)(a). The test, my lords, which I can recite from memory, having reread the article many times, is nothing in this article shall prevent the state from making a law to regulate economic, financial, and political activities or financial, political, or other secular activities associated with religious practice. The word essential doesn't come there. And I would emphasize, I think Mr. Dwivedi had pointed that out, the word is associated. It doesn't say part of religious practice. So therefore, my lords, in my respectful submission, the essential religious practices test, which came about through mere verbal sleight of hand in Shirur Mutt, the Attorney General posed that as the question to be answered in terms of 25(2)(a). The court simply answered by saying, what is essential has to be looked at in terms of religious doctrine, the doctrines of that religion. And I'm not even sure intended to say that the word essential is important. What was intended to be said was that one will go by the scriptures and doctrines of the religion.
Essentially religion, not
Which
essential religion.
my learned friend Mr. Sai Deepak had suggested.
Was the context of the paryaya.
Yes,
Once in 2 years,
yes,
the Ashtamatas,
yes,
there is a paryaya,
yes.
to which Mathadipati will be in charge of the Krishna Matha. So the extent of expenditure which was required, that was the controversy.
That's right.
When the Matha was already under debt
Of 1 lakh or something.
at those days.
Yes,
Therefore, they brought a scheme to ultimately take over that Math.
that's right.
That was the controversy there.
Absolutely right, Yuli.
And paryaya is essentially religious.
Yes, I bow down. I bow down.
Doesn't mean essentially religious practice.
That's
Please
right.
look at
That's
the
right.
Context
That's
of the
right.
facts of that case.
Yes, absolutely. I've dealt, my lords, with this aspect in detail from para 32 onwards of the main submission. I'm not going to repeat all that. All that I will say, my lords, is that this raises the problem which has been commented on repeatedly of an ecclesiastical jurisdiction of the constitutional courts, which ought not to exist, is my respectful submission. And, my lords, whether it arises in a civil suit, to answer a question that I believe my Lord Justice Bagchi had posed, whether it arises in a civil suit or whether it arises in a constitutional challenge to legislation, the question of what is religion and what is a religious practice ought to be gone into only as a matter of evidence by taking evidence, and if it cannot be done by looking at the scriptures, by taking evidence of experts. It ought not to be gone into as a normative preference of the court. And that is why I say the test in Dargah Committee as well, which added to essential religious practices, where His Lordship Chief Justice Gajendra Gadkar said, superstitions which are accretions to the religion must be excluded. I respectfully submit that that is clearly a matter of normative preference of a court, which ought not to be done when one is examining a matter which is religious. That's my respectful submission. And, my lords, therefore I say, in order to give religion its rightful place in the affairs of the country, one should allow religions to conduct their own affairs. Interference should be permitted on very narrow grounds, which is the specific grounds mentioned in 25(1) and 26(1). And I will come to that issue. I agree with my learned friend, Mr. Shankaranarayan, as well as Mr. Dwivedi, when they say that the other provisions of this part can only mean provisions, my lords, where individuals are entitled to exercise their rights against other non-state actors. So therefore, my lords, it would become 17, untouchability, 23, begar, 24, child labor, and of course 15(2), which is not allowing people to enter into various public places, including shops, wells, bathing tanks, etc., on grounds of religion, race, caste, gender, etc. These operate, my lords, between individuals and non-state actors. And one important qualification here, my lords, I believe others have commented on it. Other provisions of this part must include Article 26 as well, for purposes of the individual's right to freedom of conscience and freedom of religion, which is I'm using as a, my lords, composite for freedom to practice, profess, and propagate religion. And my lords, I wanted to also answer my Lord Justice Sundaresh. I wanted to mention that the word religion is mentioned in 25(1) at the very end. Religion. And to, my lords, answer another observation made by my lords, word religion should be contrasted with denomination, religious denomination. It is not only in 25 and 26 that religion versus denomination exists. Please see for a moment in the text of the Constitution, my lords. In 27, payment of taxes, no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Used differently. Again, my lords, in 16.5, if my lords come to 16.5, nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. So again, the contrast.
Trying to say is that, see, what is important, why it comes in a sequence. First, there has to be conscience. Then you have the right to profess that conscience. Then it becomes a practice, and then propagate. See, religion, it may be with few people, it may be an individual person, it may be a group of persons, a larger group.
Yes.
To understand it in a particular way, what it exists today is a difficulty. We can leave it to the individual concern or the person's concern.
Yes.
That is what I was trying to say.
I bow down, my lords. I bow down.
Not think it like a Christianity or a Muslim or a Hindu religion or Jainism, Buddhism. Let us not confine it with this. Because in any case, 26 says about religious denomination 6.
Yes.
So the idea is that the conscience leading to the religion and the profession practice should have a concrete shape.
Yes.
For that purpose, the common belief, person with common belief, they constitute religious denomination. See, ultimately, this is a conscience that is ought to be protected.
That's right. That's right.
Now, see, conscience comes first because that's the starting point.
Yes.
It's like a rainwater, gets in and thereafter it partakes different character, gets ultimately into the sea. But the conscience is important.
I bow down.
Your conscience, my conscience, they just, merge with each other, followed by the other practice. It is that one which is of paramount importance. We can't give a restrictive meaning to that. That's what I'm saying.
Very well, my lords. I just want to add, my lords, now I'm moving onwards, my lords, to paras 8 onwards of my submission. The short point I'm seeking to hear, my lords, that is in the short note. The difference, my lords, in the nature of the rights conferred by 25 and 26, I now want to say a few words, my lords. 25(1) is the right of an individual. And if one looks, my lords, at the nature of the rights, they are in the nature of individual rights. That is to say, the individual's right is his freedom of his individual conscience, his right to profess, practice, and propagate as an individual. On the other hand, in contrast, 26(1), my lords, is the right to institutional autonomy of a religious denomination. And what are those rights? To establish and maintain religious and charitable institutions. An individual may also have that right. That is, he may try to do it, but he has to do it within the organized framework of the denomination. Second, to manage its own affairs in matters of religion. Third, to own and acquire property, that is of the institution. And fourthly, my lords, to administer the property. Please notice, my lords, it doesn't say, that is, it says to administer property in accordance with law. This in accordance with law is pertaining to the administration. It can't be used as an excuse to make a law to interfere with the 26C right, which is to own and acquire property. I am not, my lords, for a moment saying that in case of every, and I'm going to the last page because this is one of the most important aspects of what we wanted to place before my lords.
In accordance with law,
Yes,
when it colors administer property,
yes,
by necessary implication include own and acquire property. It may be in distinction to the establish, administer, and manage affairs of matters of religion, which are unique to temporal aspects like property.
my lords, I'm taking a slight,
Making a distinction
To
between
administer such property
making distinction
according
between religious
to
affairs and
Constitution
owning
of
property.
yes, my lords, I bow down, my lords, except that I'm on a slightly nuanced difference, my lords. I'm on a slightly nuanced difference. I'm saying the words own and acquire property in 26C are not qualified by the words in accordance with law.
You understand?
Only in D,
If you see the four clauses,
yes,
the first two clauses are with regard to the core religious activities. That is to establish and administer a religious institution and manage its affairs.
yes,
So it is more like an indoor management of a religious institution controlled by the denomination or any section.
yes,
The two are secular and therefore governed by general law. And the first two, being religious, have to be restricted to the subject clauses, namely public order, morality, and health.
yes. I bow down, my lords.
I
May,
agree.
may I say this, my lords? I do believe that the state must have the power of eminent domain, that it can exercise its power to acquire by passing a law. But I would like to put in some nuanced caveats here. My lords may come back to the last portion of the note, the big note, my lords. I'll come back to the middle, para 37 onwards, the second last page of the note. Page 6.
Yeah, correct.
My lords, from the standpoint of my religion, I wanted to divide it, my lords, into two categories. There are, my lords, in fact, there are three categories, my lords. First is natural sacred sites. This, my lords, is where the site itself is worshipped as being divine. I hope, my lords, I'm clear on this. So there are certain sites in the Jain religion where our Tirthankars actually attain salvation. And those sites, my lords, are worshipped as divinities in themselves. Those sites, my lords, I am respectfully submitting, ought never to be permitted to be acquired for any purpose, unless, my lords, the fate, I'm hazarding a guess, the fate of the nation depends upon it. The nation would be extinguished. These are, my lords, imponderables. But other than that, these divine sites should not be permitted to be acquired. Second category, my lords, are the examples, my lords, are, for example, there is a Parashnath hill where the 23rd and 24th Tirthankars are supposed to have attained salvation. That site, my lords, ought to be kept sacred and should not be permitted to be acquired, is my respectful submission. And this has been recognized, my lords, in the Constitution Bench decision in Acharya Maharaj Shri, which is at page 39 of my submission, that the right under 26C was not absolute and a denomination's property could be acquired. The caveat is, my lords, If, on the other hand, acquisition of property of a religious denomination can be proved to be such as to destroy or completely negative its right to own and acquire movable or immovable property, and I'm emphasizing for even the survival of a religious institution, question may have to be examined in a different light. This is not quite capturing the sacredness of the site, but the point is there are points at which the courts, this honorable court, has recognized a line which should not be crossed. Then, my lords, created places of worship.
But for the sake of public order,
Yes.
suppose two denominations of the Jaina faith start fighting over a religious site and there is public order threat, then the state can intervene.
My lords, I would bow down to that. That is a possibility, my lords. But except for those exceptional situations, my lords, and there the state would be preserving the site for worship, not taking it over and building, let's say, district headquarters on it. That's my only caveat to that. Then, my lords, in other words, the power, that is, this court would be very circumspect in allowing the state to interfere in these matters. Then, my lords, comes created places of worship. That is, I build a temple, I build a place of worship. Those, my lords, if they are of long standing and have attained great spiritual significance, they ought not to be acquired, but in rarest of rare circumstances, ordinary places of worship can be acquired is the difference. Then, my lords, I just wanted to point out in Mohammad Ismail Faruqi, 1994 Supreme Court, this honorable court held that places of worship of any religion having particular significance for that religion to make it an essential or integral part of the religion stand on a different footing and have to be treated differently and more reverentially. Yes.
Out of anxiety, that Shavana Belagola, is it a natural place or a created place of worship?
I think
Bahubali, the great
my lords,
idol.
my friend Mr. Divan tells me that it is probably a created place of worship and therefore possibly could be acquired. There's a monolith there apparently.
Yes.
But my lords, these factors which are put at the
Actual place of worship, they treat as a created place of worship. Yes, sir.
long-standing nature of the place of worship, its reference in scriptures, its relevance to customs and norms, and its role as place of convergence for believers. If that is the case, then at the very least, the state is bound to find an alternative place for whatever its purpose is. And lastly, my lords, I say, where there are properties which have been acquired for the sustenance of the religion, in that case, it can be acquired, subject, my lords, to the three conditions I put at the very end of the submission. They must comply with constitutional requirements, that is 300A, fair and reasonable compensation, denominational consent where possible, and to the extent possible, the acquisition must not interfere with the carrying on of religious functions. Yes. At page 481 in more detail, my lords, in the main submission. Then, my lords, I come back to this institutional autonomy point. I just wanted to point out the difference in the nature and character of an institutional autonomy right as compared to the individual right, where I submit with respect, in view of the inclusion of the words other provisions of this part in 25(1), 26 rights would prevail over 25(1) rights. The Sayedna, my lords, case, there's two passages which I have extracted, my lords, at page 2. Your lordships may kindly see that. Para 12. A denomination within Article 26 and persons who are members of that determination are under Article 25 entitled to ensure the continuity of the denomination, and such continuity is possible only by maintaining the bond of religious discipline, which would secure the continued adherence of its members to certain essentials like faith, doctrines, tenets, and practices. Then, my lords, I read the highlighted part after denomination is a common faith, common belief, and a belief in common creed, doctrines, and dogma. A community has a right, and that may, my lords, furnish the basis to distinguish between what is a denomination and a religion. If you have a generic belief in any and all creeds, that may not qualify as a denomination. It must be more specific. People who believe in a specific set of beliefs that are common to them and common creed, doctrines, and dogma, they would be a denomination. A community has a right to insist, this has fallen from my lady as well. A community has a right to insist that those who claim to be within its fold are those who believe in the essentials of its creed, and that one who asserts that he is a member of the denomination does not at least openly denounce the essentials of the creed. For if everyone were at liberty to deny these essentials, the community as a group would soon cease to exist. And Dr. Dhawan had also talked about this aspect, my lords, the need for the institution to maintain its coherence to survive. And therefore, my lords, I submit that what has fallen from my lords, that a public interest litigation should not happen, where a non-believer comes and seeks to oust the practice of a creed, ought not to be permitted. Also, to answer a point that had fallen from my lords earlier, my Lord Justice Bagchi had voiced apprehensions about, say, cannibalism as being a religious doctrine. I'm told there's a tribe of Agoris who eat corpses, my lords, etc. I believe most of these cases, the state would intervene on its own, and if it doesn't, certainly, and they can certainly pass a law saying that it offends morality and health. And even if somebody were to come and enforce through a writ, IPC provisions, municipal regulations, etc., that would certainly, my lords, be permissible. Then, my lords, I move on to my lords, untouchability. I just wanted to point out something, my lords. Untouchability can be held even against denominations by simply noting. Devaru, my lords, as my friend, learned friend, Mr. Dwivedi pointed out, tried to harmonize between an enabling state power in 25(2) and, my lords, the denominational rights under 26. That is 26B, right to manage its own affairs. I'm respectfully submitting that's not a permissible way to harmonize. But there are two rights, my lords, in the Constitution which stand on an equal footing, the same pedestal. One is 17, untouchability. The other, my lords, is 26, which is a denominational right. I am saying by harmonizing the two, untouchability must bind even religious denominations. They cannot be permitted to practice untouchability. And then it would follow automatically, my lords, if you are allowing even untouchables to enter your temple, then all persons would enter the temple from that religion. That is, all castes would come in normally, because it would go against the normal practice, my lords, that I would allow untouchables because of 17, I would not allow some other specific caste or community not to enter. Then, my lords, I come straight away to the test, my lords, which I believe should be employed under Article 25. This is, my lords, on the position that possibly your lordships say that it would apply. 25(2)A would apply both to religion and to denominations. I'm proposing, my lords, a 5-step test. The word, my lord, secular has a negative connotation. So it may be assumed that the state need not establish that its law is intended to target something secular. That is non-spiritual, temporal because it is not spiritual, and therefore it needs to prove nothing. I'm saying there are 3 words that precede it: economic, financial, political, and other secular. Other secular must take its color from these 3. These have a definite content. What is economic, your lordships can clearly discern. What is financial, your lordships can discern. What is political, your lordships can discern. And those may be permissible to regulate, provided they are merely associated with. The Constitution framers could have used the word part of, but did not. They did not say part of religious practice, they said associated with. And therefore, my lords, in my respectful submission, the state should have the burden of establishing first that it is economic, financial, political, from para 20 onwards. Second, my lords, and I've annexed these definitions, my lords, to show the definite content of these terms: economic, financial, political, and secular. My lords may note that 25(2)B uses the word social. Again, social may be contrasted with religious. Therefore, my lords, the example would be that you may, my lords, regulate the running of a business by a temple, the renting out of shops, or an educational institution. You may not, my lords, in my respectful submission, enter the precincts of the temple itself. And I want to emphasize to my lords the importance. My lords may recall from the Rajkumari Amrit Kaur discussion, she wanted to say social reform in respect of religious worship, but they ultimately substituted the words religious practices because they did not believe that it was worship, these social evils. I am saying religious worship, my lords, within the precincts of the temple must encompass everything associated with that worship, including the taking of contributions from believers and running the temple staffing, management, etc. Shirur Mat, my lords, in my respectful submission, went wrong in wholesale upholding the provisions of the, not wholesale, picking and choosing and allowing certain provisions of the Hindu Religious and Charitable Endowments Act. I respectfully submit the state ought not to be running temples. I personally have appeared before two of my lords, my lady Justice Nagaratna as well as my Lord Justice Sundaresh, in the context of a temple Devaswam committee, allowing the sale, my lords, of 16th century artifacts at a temple to be used in religious processions donated by the Cochin royal family that were allowed to be broken up and then made, my lords, according to them, into some new temple elephant headdress for religious processions. This is the sort of thing that can happen when the state gets involved. I was also involved, my lords, in the Padmanabhaswamy temple case, where the state tried very hard to take over management. So, my lords, then the third test, my lords, I wanted to point out in paragraph 25. My lords, 25.1 is not intended to confer protection on activities. But the freedom to practice regulate religion, my lords, is not intended to confer protection on activities that are actually economic, financial, political, or otherwise secular. But it is not intended to create a wide legislative field for regulation of religion. For instance, within the Jain religion, the management and administration of temples is not considered a secular activity. It goes beyond seva or volunteer work and is seen as an act of great worship. Thus, trustees who are discharging religious obligations are not permitted to divert funds meant for one religious purpose, such as Dev Dravya, for another religious purpose, such as Gyan Dravya. So the point, therefore, my lords, is that you can have economic and financial activities that are part of the religion and not merely, my lords, outside the religion. That's why I gave those examples associated with. Then, my lords, the other test which I wanted to suggest to my lords for judicial review of legislation purporting to be under 25.1 is the regulation of general application. If it is a secular activity that you're regulating, please include a test that it must be of general application to all persons, religious and non-religious, conducting that secular activity.
Yeah.
It should not be specific and targeting the religion. Then, my lords, the proportionality test, which your lordships are aware of from Puttasamy, and the least restrictive alternative, if you are regulating the least restrictive alternative. And, my lords, the last test which your lordships have commented on, does the law extinguish the religious practice completely? Then, my lords, and the COVID example, my lords, your lordships allowed the Rath Yatra to take place by regulating the number of people who would be there rather than banning it absolutely, is an example of how the regulation can be least restrictive while allowing the religion to proceed. Then, my lords, one important point, then one point on Article 25(2)(b). Your lordships would have noted that the explanation says that the word Hindus must be read as Jains, Sikhs, Buddhists. I am submitting that that cannot be mean in the second part of 25(2)(b) that one would allow Hindus or Sikhs or Buddhists to enter Jain temples. A law should not be made to that effect. That is, that Hindus, Sikhs, and Buddhists should be entering Jain temples. The phrase in 25(2)(b) should be read as throwing open of Jain religious institutions to all classes and sections of Jains, and not vice versa, because Jainism is an independent religion. And then lastly, my lords, I'm respectfully submitting, your lordships may kindly consider holding that Articles 25 and 26 are part of the basic structure of the Constitution. This is extremely important, my lords. In S.R. Bommai, there was a concurring opinion of Justice Emedi, which said, these fundamental rights enshrined in 15, 16, 25 to 30 leave no manner of doubt that they form part of the basic structure. Similarly, my lords, in Indira Gandhi versus Raj Narayan, Justice Chandrachud held that it forms part of the basic structure. And, my lords, Articles 25 and 26 incorporate the ideals of equality. Your lordships may recall the words equally entitled in 25(1), which makes it a secular constitution. Freedom of speech and conscience, because of freedom of conscience, my lords, in 25(1), and dignity, my lords, the dignity that is allowed to an individual in terms of his freedom of conscience and his freedom to profess, practice, and propagate. Therefore, and lastly, my lords may note that it is also part of the basic structure. It is also part of the basic structure because the preamble, which has often been drawn upon by all judgments that deal with what is part of the basic structure, talks of liberty of thought, expression, worship, etc., which includes and incorporates freedom of conscience. I'm most grateful to my lords for a very patient hearing, my lords. Extremely grateful.
submissions, my lords, with the nodal council. I'm not sure if it's part of the drive. If it is not, I have copies, my lords. I'm just handing over the copies.
Which volume you want?
My lords, actually, I passed it on to the nodal council, my lords, but I'm not sure if it's in the drive or not. So I'm giving a copy, my lords, physical copy. My apologies for that, my lords. You have shared, yeah. We have shared, my lord. Perhaps it has not come in the drive. It's not uploaded in the drive. So sorry. Now, my lords, what I've done is my detailed submissions are there. The paper book contains a summary also. But to save time, my lords, I have distilled it further with a 4-pager.
The note is sufficient.
Yes, the 4-pager. Because in fact, when I'm starting at this stage after 6 days, I'm feeling like the apocryphal son-in-law under Hindu law, my lords. There was a case argued before an English judge back in the 20s, where intricate questions of Mitakshara and Dayabaga law came before the English judge, who will get how much share will come for each hair. The judge was so nonplussed and exasperated. He saw Sir Alladi sitting in court and asked him, please tell us how much the son-in-law will get. Pat came the reply from Sir Alladi. He said, how much ever he's able to lay his hands on. I seem to be in that position now, my lords. So much of elaborate debate having taken place. Let me see what I can grapple with, my lords. But before I get into any of this, I will endeavor, my lords, not to trouble my lords with the nitty-gritty of the contents. I'll broadly give what I want to say, my lords. Part 1, I want to deal with all the questions under one group, my lords, with regard to 25, 26 and the interplay of those. But I assure my lords that I'll be dealing with it in a slightly different manner. I will not repeat. Part 2, my lords, is with regard to broadly the subject of judicial review. Because in my respectful submission, the questions which have been referred would broadly fall under this category. Now, coming to my lord's consideration of the reference and the questions themselves, I would respectfully submit it is really potentially in 4 scenarios that the questions will arise. Scenario 1, a believer belonging to a denomination questions customs or practices of the denomination, particular practices. That's scenario 1. Scenario 2, there is dispute between 2 believers within the denomination itself as to what the tenets are. A third scenario is a non-believer questioning the tenets and, my lords, the practices of a denomination. Fourth scenario, my lords, is state intervening with some legislative measures which impact upon religious practices and therefore the validity of the actions based on that, my lords. It's really broadly in this framework that disputes really come up. And it is really in the lens of this possible potential scenarios, my lords, that I would like to address the issue. That I've captured, my lords, right at the beginning of my note.
ABCD.
That's one, my lords. Now, while looking at this on substantively the interplay between 25 and 26, in my respectful submission, the first point, my lords, to be noted is this. Looking at 26 itself, one important constitutional principle, it's a settled and sanctified principle of constitutional law, my lords. Restriction found in one fundamental right cannot be read as a restriction on another fundamental right. That's one important formulation I want to place right at the outset. I go back, my lords, to Sakal papers, 60s. Sakal papers very simply was this. Government bringing in a regulation on the number of pages a newspaper would have based on the price that's being charged. That was questioned by the newspapers as being violative of their 19(1)(a) right. The government took the contention that this is traceable to power of the government to regulate business. 19(1)(a) versus 19(1)(g). 19(6), my lords, was invoked by the state to say that this is justified. My lords, on considering fully the law, have specifically held that it cannot be. Whenever there are fundamental rights which are claimed, and 2 of them are also involved, looking at freedom of speech and expression in 19(1)(a), only those restrictions which are found in 19(2) can be considered. And if the measure of the state is not falling within any of those 8 heads of 19(2), that cannot be the basis for restricting the freedom of speech and expression.
You are invoking same analogy for 20.
I am invoking the same approach and principle.
Understood.
One. Another judgment in the same line, my lords.
Something like a hierarchy of fundamental rights.
Really not. In fact, in Sakal, my lords say how all are enjoyed equally. All the rights are enjoyed equally.
Someone argued about the same issue
Uh,
earlier.
No, but it was in a different context that was argued, my lords. It was really in a slightly different context. I am placing it on a sanctified constitutional approach in terms of how to interpret two rights. Following that, my lords,
Probably on the context of constitutional morality.
well,
Okay, remember correct.
perhaps in the yeah, I think in the constitutional morality, the second judgment which I want to point out now was referred to. That's Kaushal Kishore, my lords. Kaushal Kishore, a more recent decision. In fact, interesting approach in Kaushal Kishore, they were discussed as verticals and horizontals. The approach or the action of states when they deal with or interfere with fundamental rights were dealt with as vertical restrictions, and rights which are claimed by non-state actors as horizontal or horizontal rights. So vertical rights as against the state and horizontal against the non-state actors. Now, there is a debate constitutionally, internationally on how vertical and horizontal rights have to be understood. And the general consensus, though, it says that wherever there's a vertical, horizontal will move into it in that sense, perpendicularly. But my lords have said it is always appropriate to rationalize. It is not appropriate to look at them as pure vertical or pure horizontal. There has to be an amalgam depending on the situation. That I am placing for my lord's consideration. In Kaushal Kishore, my lord said, look at the substance of the rights which are involved. Based on that, take a decision how rights will horizontally operate. It is here, my lords, I think this is really the gateway where, my lords, we need to look at what 25 and 26 stand for. There were several submissions made, my lords, on what the true purport of 25 and 26 are. One submission saying this is separate and 26 is separate. And one submission saying 25 represents the individual while 26 represents the group. And a third approach saying that 26 is a collection of the rights embodied in 25. I respectfully submit the approach perhaps might be more appropriately this. 25, my lords, refers to a religion, which is basically practice of a belief system by an individual. When we move on to 26, we are looking at a group of persons who exercise their belief system in common. Perhaps this might be a more simplified approach to the entire thing. Because with great respect, what would happen is if 26 is seen as some kind of a derivative of 25, in terms of, my lords, saying that it is only the collection or a conglomeration of 25, several complications would arise. And in the context of the present reference, my lords, 25.2, which is staring on the face, it is virtually becoming a vexed question. What is the effect of 25.2? Does it operate on 26? If it does operate on 26, how much does it do? What is the purport of Venkatramana Devaru? That is where, my lords, in my respectful submission, the entire discussion is revolved. Please, to start with, look at, my lords, 25 and 26 in this prism. 25 refers to belief system and practice of the belief system by an individual. When the same practice takes place, my lords, as a group, then, my lords, it really acquires the color of a denomination. I'm consciously not, my lords, going into whether a religion is a denomination. I think in my respectful submission, that may lead to consequences which are anomalous in certain situations.
Yes.
In fact, there is another reason for this. My lords repeatedly refer to this, and that is very important. 25 uses the expression religion, 26 uses denomination. The easiest way of rationalizing.
26 is also captioned as religious affairs.
Correct.
The
That's correct.
expression religious is there,
Correct.
but it talks of religious affairs.
Correct.
25 talks of religious
Practices. Correct. That's right, my lords. And there, the important distinction that I want to highlight is this. 26 talks of denomination or a section thereof. That's important, my lords. That section also becomes important. Now, section thereof becomes important for one important purpose. There may be instances where, on a general understanding of what a denomination is, there may be a group of people who may not fall within that, but they will still be a section of a denomination. It's really for that purpose that I'm highlighting it. In fact, that's where I just want to move on to the next point, what I want to highlight, my lords. What is the meaning, my lords, to be attributed to the word denomination itself? What is the definition? Being an undefined term, a number of submissions have been made, formulations have been given, my lord. I have attempted a very, very straightforward formulation, my lords. I had occasion to discuss with Dr. Dhawan. He appeared to broadly agree that this formulation might be an answer. Please have a look at it, my lords, for a minute. Please come to page 2, para 6.
Yes.
The three-way formulation of a denomination, as set out in decided cases, does not adequately address the meaning of a denomination in the context of the heterogeneity of the Hindu faith. This is important in my submission, my lords. Page 2, my lord, my ladyship, page 2, para 6. Meaning of denomination. A more appropriate definition of a denomination would be that it is a collective or group of persons who, even while belonging to a common faith, that is a religion, have special attributes by way of a belief system. And the qualification I've given is a little important in my submission, my lords, with reference to a deity or a preceptor or an institution, and practices in furtherance of the same. If ultimately, my lords, see on a summation of all practices, in fact, this is in my submission, religion neutral, though it is particularly perhaps necessary in the context of the Hindu faith, the heterogeneity of the Hindu faith. If my lords see ultimately, what is it that one group varies from the other with? It would ultimately be with reference to preachings of a particular preceptor. Or it may be, my lords, with reference to a particular deity. My lords, we have this wonderful idea of Ishtadevata, where in the Hindu faith, there are people who propitiate particular figures or forms of the deity. That's Ishtadevata, that's recognized in Hindu law. And in fact, we have the deity being propitiated in different forms. You go to the tip of the country, my lords, Kanyakumari is the place where, my lords, the mother is in the form of a Kanya. The goddess is in the form of a Kanya, a small child. To contextualize, my lords, the reference for Sabarimala, my lords have been told already, he is a Naishtika Brahmacharya. There are several forms. We have 64 forms of Shiva. In Shiva itself, my lords, Bhairava is one form. Bhairava itself again has several forms. We have one form of Shiva which is reflective of silence, which is Dakshinamurti. My lords will see in all Agamic temples which are consecrated as per Agamas, the Dakshinamurti will be found only in what is called the outer circle, which is the Koshtam, the outer Praharam. Now, the idea behind Dakshinamurti is he is facing southward, which is not normally done. And religiously, philosophically speaking, he teaches and preaches through his silence. Therefore, my lords, I'm highlighting this only to show how there are several belief systems. There are several practices connected to that. All may come within the larger umbrella of Hinduism. It would not, in my respectful submission, be appropriate to look at Hinduism as being broadly covered by the 6 broad schools, as it were, with reference to Shaivism, Vaishnavism, or Shaktam, or Kaumaram. For example, my lords, Kaumaram, which is of Lord Kartik. Kartik is how the Lord is understood here in this part of the country. It is a major source of worship in the southern part of India. There is following for Kartik, my lords, in forms which are unbelievably diverse. Therefore, it goes far beyond that. In fact, I remember Swami Chinmayananda once said, Hinduism swings like a pendulum. between the limits of theistic theism and atheistic atheism. That's the extent to which, my lords, the religion swings. Now, therefore, in the light of that kind of plenitude of practices and beliefs, please look at a denomination as a set of people who have come together for certain common beliefs with reference to a particular deity or a preceptor or an institution. And their practices and customs may be different from the general group. This is one submission I wanted to make. Lord.
Look at it only from the Hinduism point of view.
Correct. That's
And
correct.
non-Hindu religions,
Even there,
denominations also have to be protected.
absolutely, my lords. And in my respectful submission, this formulation which I'm submitting is religion neutral. This will equally, my lords, in my submission, accommodate and take note of differences, my lords, in various in all religions. What I'm submitting is perhaps more accentuated for the Hindu context. But it does not, my lords, exclude the approach or the formulation to be taken for other religions also. This is one point I wanted to highlight, my lords. The second point is, my lords, in the light of this definition, two more things on, my lords, 26 itself before I go into the interplay between 25 and 26. It is very well established, my lords, that a constitutional provision or the constitution itself is the grand norm. In the hierarchy, the grand norm is the highest, from and out of which everything else emanates, all other forms of state action, be it legislation, subordinate legislation, or even further down, any kind of regulations, etc. Please, therefore, note that 26 is the grand norm. It is part of the grand norm. I've given reference, my lords, to the judgment right in the same page at paragraph 4. Concept of grand norm right at the beginning. Please see that. I mean, there is voluminous material, my lords, on Kelson's theory, positivist theory of grand norm, etc. But one judgment I've cited, I didn't want to burden, my lords, the court with all the theoretical material on that. Just have a look at that. My lords have taken note of it in that judgment. It is a hierarchy. That judgment, my lords, unfortunately, my colleagues, my lords, had just missed out in adding to the judgment volume. I've given a separate copy, which is at the end of the volume, my lords. It's a separate...
State of Andhra, Lakshmi Devi.
Lakshmi Devi. The copy itself is there at the end of the volume, my lords. It's a separate compilation.
We'll get it, no issue.
Yes.
Relevant part you are reproduced.
Yes. As a hierarchy of legal norms, headed by what? That is Kelson, calls as the grand norm the basic norm. If a legal norm in a higher layer of this hierarchy conflicts with the legal norm in a lower layer, the former will prevail. This honorable court further held that in India, the constitution is the grand norm, and if any statutory law, delegated legislation, or executive orders contravene the provisions of the constitution, the former will prevail. Now, my lords, I'm saying this for more than one reason. One, 25(2)(b) talks of legislation by state. In the first place, it is an enabling provision. That says how any law made or state, if it wants, can make legislation in two parts. Again, I'll not go into all of that. Now, this is basically, therefore, legislative power which has been recognized. Can it be the position, for the purpose of the present reference, this is a question I'm placing for my lord's consideration. Can it be the position that a legislation traceable though to 25, can it control 26 or condition 26? This is really the point I'm placing for my lord's consideration. I respectfully submit, my lords, 25(2)(b) has to be understood for its reflection of the anxiety of the constitution makers to ensure that if there are any social evils, then the state must have sufficient handle and leverage to deal with them. To thereafter, my lords, say it is being elevated to the level of a fundamental right. In fact, that's the reason why I wanted to get into Devaru after mentioning all this. Devaru, in my submission, my lords, proceeds on a certain basis where there seems to be one problem, one fundamental problem. 25(2), an enabling provision for, my lords, the legislature, for the state to make a law, has been looked at as reflective of furthering fundamental rights or referring to fundamental rights of other citizens. That's how the discussion takes place in Devaru. Therefore, the court has really gotten into this approach of looking at how 25 as one fundamental right and 26 as one fundamental right, they have to be looked at and they have to be harmonized. In my respectful submission, the approach looking at, my lords, legislation being an enabling power under the Constitution has been looked at as some kind of a reflection of fundamental rights. On the contrary, my lords, 25(2) reflects some kind of the power available to the state to ensure that what is exercised in 25(1) is not inconsistent with social requirements. The conflation of the two, my lords, results in consequences which are extremely anomalous.
Yes, sir, there's some difficulty in appreciating. 25(1), it only, not only says public order, morality or health.
Correct.
It also subject to the other provisions.
Provisions of Part
It
three.
means there's been nothing wrong in relying upon the other provisions. It is not the justification of the state action. It is the adjudication upon the action on the part of denomination, religious denomination.
Correct. In fact,
So in
I'm
this case, 25(1), it delineates the powers of the religious.
the broad framework.
It is subject to.
Correct.
Which means some of you also argued, what do you mean subject to?
Correct.
When it's subject to that, you cannot get into that. If you try to get into that, then obviously courts can intervene. That's what they will say.
That's correct. No, there with one qualification. I understand, my lords. I bow down.
Incidentally, it referred to 25(2)(b). That's not an issue at all.
No, there, my lords, I'll tell my lords why I feel, my lords, there is an anomaly which requires to be considered, which I'm.
If there is a breach, then they can enact law under 25(2)(b).
Correct.
It may be one of public order, morality, or health,
Correct.
or in order to give effect to the other parts of the part 3.
With one qualification,
Yes.
lords. I'm so sorry. 25(2)(b), in fact, confines the enabling power to two aspects. One is, my lords, social reform. Please see the first part of 2(b). It's in two parts. So the enabling power also, my lords, is confined. Please have a look at this. My lords have seen it.
You are right. To that extent, we agree.
Yes.
It confines the power. So, but they can trace it. See, it may come under the part 3 also, but it also be a social reform. When you talk about social reform or social welfare, it may be a public order, it may be one of public health, it may even go under this part 3. Or yes, my brother has Bhakti has put it. It may come under the fundamental duties also.
There I have a separate submission to make.
That's a different matter to be looked at.
That's a different issue, my lords, at least for the time being.
Yeah, that's correct.
But one aspect I'm highlighting, my lords, the problem really arises when there is a conflation of this with 26. Please go to my scenario 1, where, my lords, a believer in the denomination makes a claim which goes contra to the practices or customs of the particular denomination to which he belongs, or the state makes a legislation on that. Now, state making, that is the fourth scenario I pointed out. State making legislation, my lords, in my submission, would be necessarily have to be subject to the rigors of 25(2) itself.
Venkatramana Devaru.
Yes.
Legislation was under 25(2)(b) itself.
Correct. It was under 2(b) itself.
The claim was that legislation cannot impact because we have a right under 26(b).
Correct.
Therefore, one cannot negate the other.
Exactly, my lords. Having said that,
26(b) cannot negate the right of the state or enabling power of the state under 26(2)(b).
no, there.
Therefore, the court said we have to see what is that proportionality.
Correct. Now, there, in fact,
Harmonizing.
yeah, harmonizing was one of the things it did, where it said, please look at what is left out after the restriction under 26. Is it only the husk or a substantial portion which is left out? And there, one important aspect which is perhaps lost sight of, my lords, in the milieu of the discussion. The court, in the process of looking at rationalizing 25(2)(b) or 25 and 26 itself, I've given that in my submissions on Devaru, says that 25 has to take note of 26(b) rights. I mentioned that, my lords. Please come to the next page.
What was argued by Dr. Singhvi that while making a law under 25(2)(b), the religion cannot be hollowed out.
Yeah, correct, exactly.
That is what has to be seen.
Correct. And in fact, my lords, it is in that context, there is one portion of Devaru which perhaps has not been underscored in that sense, my lords. In Devaru, there were certain special claims, privileges claimed by the denomination, which were accepted by the High Court, and the decree of the trial court was modified. My lords, in recognition of that, confirmed that. That portion, my lords, perhaps we'll need a second look. What happens is, in the process of looking at how 25(2)(b) would operate to restrict or condition 26(b), the court also says three important things. Lord, just have a look at my.
Also keep in mind that arose out of a suit.
Correct.
When the matter traveled to this court.
Constitution had come in.
Constitution had come in.
Correct.
Then we were told that Mr. Nambiar, the senior counsel, wanted to go back and challenge and.
That was not permitted.
Not permitted.
That was not permitted.
You have to see the factual background.
Absolutely. In fact, my submission is precisely that as a bottom line. Devaru has to be understood for deciding what it did in front of it. That's the whole point I'm submitting for my lord's consideration, my lords. The problem arises when, as a proposition, Devaru is read and understood as holding the position, the constitutional position, to be 25(2)(b) controlling 26(b). Devaru, in my respectful submission, has to be understood for what it decided in that case. That's really that's the burden of the song, number one. Number two, the very fact that Devaru, my lord, said that 26(b) has to have its own play, and in doing so, affirmed the decree of the High Court, which granted those specific rights to the denomination, where on specific days, they could, my lords, exclude others. These two, according to me, are extremely important, and they will have to be taken note of. The problem arising out of Devaru is this. Today, it is being applied as a general principle that 25(2)(b) will condition 26(b). That's where, in my submission, my lords, there has to be some kind of clarification on what Devaru stands for. One, it is something which stands for the merit of the issue specifically before the court. Two, it said 25 has to be read subject to 26, and said both being fundamental rights, they have to be harmonized, but ended up saying that 25(2)(b) will condition 26. Third, it also says decide everything on a case-to-case basis. The problem really emanates because of how it has been understood as is found in Sabarimala. In fact, my lords, Saifuddin in 60, that's not been looked at by many people in the context of what Devaru stands for. Saifuddin, I would commend my lords to have a look at, my lords, the concurring opinion of Rajagopal Iyengar. It's there in my compilation, my lords. I've mentioned it in my main note. I have not captured it in this note, but please have a look at it. How Devaru was read and understood in Saifuddin immediately thereafter. There is a fourth aspect, my lords, to Devaru.
Yes.
The fourth aspect is this. The court, in its concern and anxiety, and rightly so, my lords, that 17 mandate is not offended, went about this exercise. But when a denomination makes a claim as to access restrictions, and this is very crucial in my submission for what I'm attempting to formulate, my lords. When access restrictions are being claimed by a denomination as part of its customs, as part of its tenets, it is not with reference to caste. It is, my lords, with reference to the fact that the denomination has certain peculiar practices. It is cutting across the board all persons. That's important, my lords. Please, therefore, look at what restrictions or curtailments that a particular denomination may provide for as prescriptions. the entirety of the discussion and approach in my respectful submission has been done only through the prism of restrictions. I am respectfully submitting, my lords, the correct approach would be to look at those as prescriptions traceable to the tenet or the doctrine or whatever it might be of that particular denomination. Therefore, my lords, one, how do you deal with a denomination itself in terms of understanding a denomination with reference to 26 and in its operation with 25? Both, my lord, another very simple approach, my lords. If, my lords, the constitution makers intended that they should relate to the same subject, they come under the head of religious freedom, no doubt about it. That is the part under which both come. There would have been no occasion to provide for 25 and 26 both separately. That's very important, my lords. If 26 is merely an extension of 25, there would have been no occasion for the constitution makers to separately provide for it.
Because they never expected an argument like this.
Not only that,
They put it separately so that the administration management will come separately, nothing else.
even
Except that we are hearing you at length. So.
26D is also, they
Yes.
want all denominations to follow
Yes,
Registration Act, Transfer of
Absolutely.
Property Act
absolutely,
with regard to their properties.
absolutely.
And not say I am denomination,
Can't.
I am separate.
They can't.
Nobody can touch me.
They
with the
cannot, my
large
lords. I am obliged to your ladyship for raising this. There's absolutely, I bow down.
Restriction on the.
Absolutely, I
Yes,
bow down.
because
Now,
it is not religious. It's a
Absolutely.
Secular thing.
no, please see. Correct,
Acquiring property, administering property
correct.
is something secular.
No, please see that there's a distinction made there. I'm obliged for that. Please see the nuance in 26. Very crucial, my lords. Please see freedom to manage religious affairs is a subheading itself. But see the main restrictions, public order, morality, and health. Every religious denomination or any section thereof, I still have, my lords, 7 more minutes. I'll complete, my lords. Or any section thereof shall have the right. No, please.
I will have to keep the bell.
A to D, my lords, please see the distinction. Now, please see, to establish and maintain institutions for religious and charitable purpose, there's a colon. B is to manage its own affairs in matters of religion. C and D, please see, they are together. Because, please see here, to own and acquire movable and immovable property and to administer such property in accordance with law. Therefore, this is where Shirur, my lords, comes in. Therefore, A and B are separated by a semicolon. C and D are connected by an and. So the constitution makers were clear that so far as C and D are concerned, which are secular aspects, they'll be in accordance with law. What fell from your ladyship, Registration Act. In fact, I would go a step further. In holding property, perhaps a denomination will require a juridical status because for it to hold property, it has to be in accordance with law. It has to be a trust or some kind of a recognized form because it says in accordance with law or an association of persons. But when it comes to religious affairs, it is where even a loose arrangement is something which will be good enough for the purpose of the constitution. This I'm respectfully submitting, would have to taken note of, my lords. Then I move on to, then my lords, I'll go straight away to my last page of my summarized note, my lords, going back to the four scenarios which I'm saying where, my lords, issues will come up before court. Please see my para 12. I'll quickly go through it, my lords.
On judicial review.
Judicial review.
Well,
No, I've given some nuance, my lord. Just have a look at it. The scope of judicial review must be seen in the light of 4 scenarios set out here and above. In each of the scenarios, the scope of review would vary. For scenario 1, where the claims of a believer belonging to a particular faith comes in conflict with the belief of the group with regard to particular customs, extent of review would necessarily have to be limited. In such a situation, courts only would have the power to determine whether there is in existence such beliefs or faiths of the denomination, and if so, the rights of the denomination would prevail over the rights of the individual believer, only subject to public order, morality, and health. Then where is second point, my lord, Justice Arvind Kumar had been asking repeatedly. Point B covers that. when there is an interstate dispute as between two believers within the same denomination or as between two denominations with regard to customs, practices, and consistent with the nature of the dispute as being purely and substantially religious, the courts would refrain from entering into a purely religious thicket. I'm specifically placing it. In fact, my lords, in Adi Shaiva, his Lordship Justice Gogoi, as he then was, notes the limitation of the court in one place. Para 43, please make a note of it. It's there in my submissions, my lords. The court says, we are compelled as a matter of constitutional necessity to get into these aspects, not in excess of any ecclesiastical jurisdiction. They note the difficulties the court would have. Then, my lords, third, where the claims of a non-believer come in conflict with the beliefs of a denominational group with regard to particular customs or practices, the proceedings as initiated in the instance of such a person would be vitiated by lack of locus standing. Sabarimala is a classic example. That's the third aspect, my lords. That's the third scenario I'm talking about. The last, my lords, is the state. When the state makes law. There, please see what I'm submitting for my lord's consideration. Where legislative measures addressing practices and customs of a denomination are put in issue in judicial proceedings, jurisdiction of the court would only extend to examining whether such legislative measures are strictly within the confines of the restrictions explicitly mentioned in 26, that is public order, morality, and health. Even in such a scenario, the court may not delve into the validity of the beliefs of the denomination, not to mention in dealing with any measure of the state, the limitations engrafted into 25(2)(a) and (b) would require a close scrutiny so that the state does not enter into the domain of religious practices under the cover of enabling provisions found therein. Profitable reference may be made to Article 13. One last thing, my lords. Talk of essential practices, much has been said. My lords referred to a submission about how it really deals with essentially religious practices. The source for that is found in what was said by Dr. Ambedkar, my lords, while discussing Article 19. Just 1 minute, my lords, in my summary. Give me the page. It's a little important, my lords, in the submissions. Just have a look at that, my lords. Page 32 of my submissions, my lords. Yeah. Now, please see para 99. While dealing with, my lords, whether personal law should be brought in and 19 was discussed, please see what he has to say. There is nothing extraordinary in saying that this is page 32, my lords, para 99. I'm just finished.
Yes, you can read.
There is nothing extraordinary in saying that we ought to strive hereinafter to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with ceremonials which are essentially religious. My lords got that. It really stems from that. When 25 talks about this, my lords, it is really that which the Constitution wanted to deal with, not as between essential and non-essential religious practices. What the court will look at is what is essential with what is not essential in terms of religious character. What is essentially religious and what is essentially secular or non-religious. Therefore, this stems from, my lords, the discussion in the Constituent Assembly itself, and that's how, my lords, the discussion took place. I rest my case, my lords. I apologize, my lords, that in fact, I thought I'll be a middle order batsman, my lords. I ended up not just being lower middle order, but tail end, my lords. That's why, though my written submissions, my lords, are elaborate, please have a look at them, my lords.
Those are with us. Those are with us. Thank you.
Okay.
Yes, Mr. Diwan.
I'm obliged.
Yes.
Because I'm going to try and confine myself to about 15 minutes. I have handed in a set of supplementary submissions, which I'll just share. I've indicated on the first page. Just give copies there. Just give copies on this. When it was on the first page, we've indicated the specific 3 sets of parties who are interveners for whom I appear. One of them is of the Jain faith, one of them Hindu faith, and one set is of the Christian faith. our written submissions and where they are in the electronic record are also indicated on the first page. And this particular note may be treated as supplementary to those submissions. Now, may I just state my point, because I'll just indicate what the point which we seek to essentially project is that this court, when it is sitting in a panel of 9 learned judges, will have regard to what we consider 3 other 9 judge bench cases or decisions which may have throw some light and maybe of some assistance insofar as guiding and interpretation is concerned. So I'm basically going to focus on 3 of these cases. The first is Coelho, the second is Puttaswamy, and the third is Mirajkar. And I'll just indicate as to how Mirajkar comes into the picture. Mirajkar read with the 7-judge bench judgment in Antule, the second Antule case. So I'll just state the point. Now, Coelho is important in our understanding because it brings up and brings us to a point of time on constitutional interpretation and how part 3 is required to be interpreted. So there are 4 or 5 principles there, which I would just invite your attention to. You may find them of some assistance. So may I just place those 5 principles and then I'll try and link it to this case. Please go to page 3 of this note, where we've extracted, just page 3 of the note. That's just a short extract from Coelho. There are 5 propositions that were laid down authoritatively by this Honorable Court, speaking through Chief Justice Y.K. Sabarimala. So para 42, the Constitution is a living document. The constitutional provisions have to be construed having regard to the march of time and the development of law. That's, I think, a factor your lordships may consider while moving forward. 43, the principle of constitutionalism is now a legal principle which requires control over the exercise of government power to ensure that it does not destroy the democratic principles upon which it is based. The democratic principles include the protection of fundamental rights. Number 3, fundamental rights occupy a unique place in the lives of civilized societies and have been described in judgments as transcendental, inalienable, and primordial. They constitute the arc of the Constitution. 4, it's evident that it can no longer be contended that protection provided by fundamental rights comes in isolated pools, can no longer be contended. On the contrary, these rights together provide a comprehensive guarantee against excesses by state authorities. Thus, post Maneka Gandhi, it is clear that the development of fundamental rights has been such that it is no longer involves an interpretation of rights as isolated protections which directly arise, but they collectively form a comprehensive test against the arbitrary exercise of state power in any area that occurs as an inevitable consequence. And the last proposition, Article 329A4 was struck down because it crossed the implied limitations of amending power, that it made the controlled constitution uncontrolled, that it removed all limitations on the power to amend, and that it sought to eliminate the golden triangle of Article 21, read with 14 and 19. The doctrine of basic structure contemplates that there are certain parts or aspects of the Constitution, including 15, Articles 21, read with 14 and 19, which constitute the core values, which, if allowed to be abrogated, would change completely the nature of Constitution. Exclusion of fundamental rights, which would result in nullification of the basic structure doctrine, the object of which is to protect basic features of the Constitution, is indicated by the syntopic view of the rights under Part 3. And then in Para 145, the second sentence, you will again find, thus the validity of such laws can be challenged, that's entry into the 9th schedule, on the touchstone of the basic structure, such as reflected in Articles 21, read with Article 14, 19, and 15, and the principles underlying these articles. So I'll just make 2 or 3 points with regard to Coelho. So the first point is that at least reading this 9-judge bench panel, which traced the constitutional history, they felt, broadly speaking, that you cannot read articles in the Fundamental Rights Part 3 in isolated pools. That's not to be done. So they draw strength to each other, from each other. And that's, I think, the court is most concerned with eventually the space and the liberty which is reserved to the citizenry in different fields. And they found that a much better way of construing and protecting these spaces is perhaps through reading them collectively and not in silos. That, of course, doesn't mean that in certain situations you do not have a textual reading or that you borrow everything from one article into the other. But this appears to be one element. The second is the expression and the phrase used is golden triangle. And I mean, I'm just picking up what Mr. Venugopal said in the first session today. Your Lordships may consider whether the time has come to expand this triangle into something which is a quadrangle, for example, and whether the right to freedom of religion, which is so important to so many citizens, also forms a part of this particular, what was a triangle, into perhaps a quadrangle, and therefore part of that basic structure doctrine which is there. So I think Coelho can be of some assistance in this regard. I leave it there. Now I come to the second 9-judge panel. I'm sorry.
You're trying to say that Article 25(1),
Yes,
with regard to your freedom of conscience,
yes,
can also come within Article 25(1),
yes.
can be read within Article 21.
No, I am suggesting that just as what our court has, on my understanding of the law, as far as Coelho is concerned, they took 14 and 15 together. They took 21 and they took the freedoms in 19. And they described this as a golden triangle and said that keeping in view the basic structure doctrine, we create this golden triangle, which, if in any manner reduced or diminished, may amount to a basic structure incursion. For your Lordship's consideration, sitting in this panel is, have we evolved, or would a correct interpretation be?
In other words, the argument is that 25, 26.
Yes, I think so.
Also deserve to be treated on the
Yes,
same
elevated.
pedestal.
Yeah, you may
as
consider
21,
that. Yeah,
as
you may
21
consider that.
Or 14, 19 have been
Yeah,
tested.
I suppose that's how the Constitution evolves, and your Lordships may certainly consider that, because there is a plank in the form of a 9-judge bench judgment which has taken us this far. If your Lordships wish to consider and take us a little further, that's really for this bench after hearing all the parties. That's one.
Because this comes in the realm of liberty of thought, faith, and
Yes,
worship.
it is. It's very primary.
One
Yes.
is general liberty as we understand it.
Yes, yes. But I think this is also, well, it's perhaps deserving. I mean, of course, every fundamental right has its own importance, but that's for your Lordships to consider. Now, my Lords, I come to the second aspect of my submission, which is essentially on K.S. Puttaswamy. Now, I'll just indicate the importance of Puttaswamy as we see it. Proportionality, as we understand it, came in initially, though not articulated exactly in that manner, in the context of Article 14. The Puttaswamy judgment is extremely important because, apart from reasonable restrictions, etc., which you already have in the context of Article 19, Puttaswamy, we read it that proportionality now is a test to be applied also in the context of Article 21. So we've come that far. Now it's for your Lordships to consider whether proportionality is a good test, because ultimately these are tools which courts use. Is it a useful tool in the context of 25 and 26? Because there is, as your Lordships have seen, I mean, a whole body of case law which has already developed, including tests which your Lordships have laid down. Those are being debated over here. But proportionality has been utilized effectively in the context of 21, in the context of 14, in the context of 19. My respectful submission is this court may consider whether the proportionality doctrine could be applied here as well in the context of both executive and. So, my Lords, we have, if your Lordship just goes back to that, I won't read it, but your Lordships will just see page 4. We have set out from Justice Chandrachud, my Lords, as he then was, judgment, which had the support of 4 votes over there. And then your Lordships will also see Justice Kaul's concurring judgment, which we have extracted at page 5. I will just read the concurring judgment because it just summarizes it and it's shorter. The concerns expressed on behalf of the panel, top of page 5, from Puttaswamy, arising from the possibility of the state infringing the right to privacy, can be met by the test suggested for limiting discretion of the state. 1, the action must be sanctioned by law. 2, the proposed action must be necessary in a democratic society for a legitimate aim. 3, The extent of such interference must be proportionate to the need for such interference, and there must be a procedural guarantee against the abuse of such interference. This is Justice Chandrachud on the previous page, which we have extracted, elaborates on this. And therefore, if there is an incursion which is made in 25 or under 26, this could be a valuable test which your lordships will consider whether it's worth reading into it. So, my lords, I should make myself clear. In the context of Article 26, and we've said that in this note, how would the proportionality principle apply? I mean, I'm just making a suggestion here. If your lordships are pleased to feel that, yes, maybe it is something we should consider, then where you have a law or an executive action based on public order, morality, and health, if you have an intervention or an incursion on that area, then apply the doctrine of proportionality to see whether those actions are valid or not. This is my respectful submission. Because if I may return to page 2 of my note, para 3C, while exercising adjudicatory, this is now my third point, while exercising adjudicatory powers in the non-judicial review situations, courts must ensure that their judgments comport to the contours of the right to freedom of religion. Incursions by the state prohibited by Part 3 of the Constitution ought not to come through court orders and judgments. Now, let me just indicate what we have mentioned here. So we first set out what in Mirajkar's case, at page the extract of Chief Justice Gajendra Khadkar at page 5. And essentially, my lord, this is the sentiment which your lordships have consistently followed, which is to say that judicial orders cannot violate fundamental rights. So that's, I think, that's a settled position, though we've also given you Justice Hidayatullah's dissenting opinion in Mirajkar, where he expresses a reservation. Now, that reservation actually played out. And it played out in the Antule case, which we have extracted, which your lordship will find at the top of page 8, where speaking to the court, Justice Sabyasachi Mukherjee found that, look, what we, the court, had done appears to have violated, and he uses Article 14. And he says Article 21 expressly, we put it out in the quotation. So while Mirajkar sustains, while judicial orders cannot impinge upon fundamental rights, and that's the settled position, and we do not request the court revisit that position. It's a good position. But there are situations where the court itself finds itself, as in Antule too, confronted by this situation. What then? So now I have a suggestion. So if your lordship feels it appropriate, then while laying down the parameters of Article 25 and 26, please also indicate in your judgment, if you consider it appropriate, that courts deciding civil disputes, ordinary suits, Section 92 situations, etc., must have regard to the parameters laid down by this court while interpreting 25-26. Because we don't want a situation where a court, in its anxiety to do justice, ignores these very paramount principles which the citizen enjoys qua the state, but which it suddenly finds is now imposition, restriction, incursion, whatever you call it, has come through a judgment. So that ought to be avoided. That's just a suggestion for the court. May I just go to point D at page 3, para 3 on page 2. The freedom to manage religious affairs under Article 26 is principally about autonomy. A central notion in human rights law is personal autonomy, and by extension, group autonomy. The freedom to manage religious affairs under Article 26 allows every religious group, and your lordships are familiar with the italicized portion. These rights are essential to safeguard the autonomous functioning of religious groups, denominations, and sections. The right to autonomy in managing religious affairs protected under Article 26 applies to all religious groups and is subject only to 3 specific areas of permissible incursion, namely public order, morality, and health. And our final point, state incursion into the right to freedom of religion is permissible only for stated constitutional purposes that are essentially secular in character. The incursion cannot result in excessive government entanglement, which fails the test of proportionality. Denominational autonomy is sacrosanct and must be preserved, or I should have said, ought to be preserved by and protected by this court. So these are our broad submissions. I'm very grateful.
Thank you. Thank you.
Yeah.
Yes, Mr. Doctor.
Lord,
exactly 15 minutes. Lord, when the matter first came in the first review, I'm appearing for the Nair Service Society with Mr. Vaidyanathan. And Lord, it was decided that I will stick to only constitutional morality. Question number 4 in the original reference. What is the scope and extent of the word morality under Article 25 and 26 of the Constitution, and whether it means to include constitutional morality? I'm not going to go beyond that. Now, my Lord, I would submit that there are 4 reasons as to why a Lordship should not interpret morality as constitutional morality. And my 4 grounds are: 1, what is the status at the Constitutional Assembly level? What were the provisions on the date of the Constitution? What is the march of law subsequently? And point which Justice Amanullah raised in the morning, will it not be a fluid concept? Why not include it as a point of a fluid concept? But though I was not here, I was watching it online because of the thing. But the first point, I've also made a short note, but I'll make my submissions. Please pass it on. Yes. My first submission is, when the Constitution was drafted, if your Lordship sees the Constituent Assembly debates, the word constitutional morality is used only thrice. On 4th December 1948 by Dr. Ambedkar, where the passage has been read, where he justifies, he refers to Grote and refers to constitutional morality by saying that, look, we're a nascent democracy, it is a top dressing, India is not ready for it, etc. So he basically means in the concept of respecting constitutional conventions, and that's the context he uses. 2 other persons use the word constitutional morality. One is a gentleman called Z.H. Lari of the Indian Muslim League. He refers to it on 8th December. And L. Krishnaswamy Bharati from Madras Presidency refers to it on 9th. So barring these 3 references to constitutional morality, there is no reference to constitutional morality at all. So my first submission is, the founding fathers could never have contemplated a morality to be constitutional morality on the basis of the debates. Point number 1. Now, Lordship will come to 26 January 1950. I'm just rushing, Lord. Please see the Constitution. And I want your Lordships to see the interplay between 13.3, 13.1, 16.5, and 25.2. If your Lordship sees 13.3 first, 13.1 and 13.3. 13.1, Lordship knows the saving of pre-constitutional laws, which says that if a pre-constitutional law is violative of Part 3, to the extent of such inconsistency, it is void. Now, 13.3 says law includes custom and usage. Your Lordship knows that, so I won't read it. So what it means is, once the Constitution came into force, the moment a pre-constitutional law was violative of Part 3, it would become void. But there are special provisions which save pre-constitutional laws. Lordship will now come to 25.2 opening part, and then I'll take a Lordship to 16.5. Please come to 25.2. Nothing in this article, Lordship has got 25.2. Nothing in this article shall affect the operation of any existing law. Now, 25.1 says, subject to this, you have the right to practice. Now, it refers to Part 3. If your Lordship links 13.1 with 25.1, the moment a pre-constitutional law relating to religion is violative of Part 3, it becomes void. But 25.2 saves it. Kindly see that. Nothing in this article shall affect the operation of any existing law. That's the first part. Or prevent the state from making any law, providing for social welfare, etc. So what the Constitution... Now please see 16.5. 16.5 and 16.2. I'm confining myself to the religious parts. 16.5 and 16.2. 16.2 says, no citizen shall on grounds of only of religion, race, caste, etc. be ineligible for or discriminated against in respect of any employment or office under the state. So if it's a religion, ground of religion cannot be a ground of discrimination. But see 16.5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of a governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. So 16.5 is an exception to 16.2. 16.2, if 16.5 was not there, the day the constitution came into force, every place where the religion was a ground to hold a particular office would have become invalid because of 16.2, but 16.5 saves it. So what my submission is, the constitution recognized in the context of religion that there are customs, usages, provisions of law which may ex facie violate, be contrary to this, but it has saved them specifically. Now, in the context of the Sabarimala case, there is evidence, the 1993 Kerala High Court judgment, your Lordship knows, my Lord, I don't know if it has been cited, the 1993 Kerala judgment by Justice Paripurnan and Balarama Marar. In a rare case in 226, they examine evidence. They examine the tantris, cross-examination, document. So 226 is evidence is taken, and they come to a finding that on the basis of the evidence that in this particular temple alone, women are not allowed in a particular period. It's a myth that they're not allowed at all. Only 3 times in the year they are not allowed. In the first 5 days they can go. So all that is recorded by Justice Paripurnan Maran. And they say they issue a mandamus that the state shall ensure that women are not allowed to go to the temple during these days. Now, I'm coming to this part. Before I'll come to 19.4.
Where do you get this?
In AR 1993 Kerala, Mahindran judgment.
It is annexed in the writ petition also. It is annexed in the writ petition as election 7.
So it is,
I'll show the passages.
which temple is this?
The Sabarimala temple, AR 1993 Kerala, the 3, that Vishu days, Makara days, etc. So the temple says. Please read the judgment. All right. Let them go on the reply. AR 1993 Kerala, I'll give the judgment. Now, please, I'm just going by what Justice Paripurnan has said.
All right, we'll
But it's AR 1993 Kerala, page 42.
But in this Article 25(2),
Yes.
with regard to existing law,
Ah.
you are saying it includes custom and usage?
Yes.
But you
Yes.
see, there is a definition of existing law under Article 366(10).
But your
Should we
Lordship,
go by that definition, or should we go by,
you must go by 13.3a.
or because it is also defining?
No, but Lordship will see 13.3a.
Yes, please see 366(10).
I'll see that. I'll see that.
It doesn't refer to a custom or usage, only law made by an authority.
But if Lordship sees 13.3a,
Yes, there it is
no, but for the
included.
purpose of part 3.
Yes,
13.3 for the purpose of part 3. Please see, because I'm in part 3. So for me, 13.3 operates and not 36. And 36 says, unless the context otherwise requires.
10.
Yes, but that says unless the context otherwise requires. So my humble submission is, if your Lordship comes to 13.3,
There, custom and usage is part of law.
yes, please see 13.3. Law includes ordinance, bylaw, rule, regulation, notification, custom or usage having in the territory the force of law.
That is law.
No,
But what
having
is used in the 25(2) is existing law.
exists. Now, Lord, please see, I've got the Travancore Act of 1950. After the Constitution came into force, on 25th November 1950, they say that there is an earlier law which is repealed and now substituted. And even before the Constitution, the custom, not ultimately custom usage having the force of law need not be a legislative law. It could be a custom and usage which is accepted by the people. Having the force of law means what? That people take it as binding. Because the word is law includes. So law cannot mean custom usage also as per an act. Even under the Contract Act, Section 1 talks of custom and usage.
Operation of any existing law, because the 1949 Act is pre-constitution
Yes.
with regard to the Madras Act of Temple Entry.
I studied.
That is preserved because it is an existing law.
Well, what happened was before the 1950, the presidency towns had thrown open the temples. After the states came, many states made the laws. Now, Travancore, Cochin, in my lordship's written submission, what do they say, my lord, in Travancore, Cochin? So, my lord, I'm just submitting that 25(2) saves customs usages that are prevalent unless the state under Article 25(2)B decides now the time has come to change it. And lordship knows the dynamic constitution. What was constituted to be unacceptable earlier now is acceptable today. That's a different issue. I am on the question of whether morality can include constitutional morality. I'm very, very confined myself to that.
Mr. Tata,
Yes,
will you read existing law
yes,
in reference to Article 13
yes.
or in reference to the other disjunctive portion of any law made by the state for certain about purposes of changing the dynamics in the religious status?
But I would put it this way, I appreciate. But why was 13(3) put there, Lord? Because
13(3) was put in respect of a touchstone of unconstitutionality.
yes,
And when you see 25(2), it is enabling. So it is enabling
yeah, enabling.
and enabling future legislations and preserving past legislations of similar nature.
Lord, I'm submitting to lordship that I get your lordship. What your
If-
lordship
if-
is saying
if
is,
we- If the legislature did not do that, then let us say the abolition of Sati Act may have been brought into question. So in order to preserve these sort of pre-constitution reformist laws made during prior independence, the word existing law was inserted in 25A and may take color. I'm just giving you a point of view. We are discussing here, it's no final opinion.
Yeah.
May take its color from the subsequent more descriptive portion of the provision.
Lord, one thing I'll mention, I've been hearing about Sati. Lordship may take it that Sati was not there in 99.9% place.
No, we are not bothered about.
No, I'm just telling you because
99.9,
Sati
but
is a
in
very
19
extreme
There
example.
is-
Even in
Lord, they only
post-independent
became
India,
because of
there
Maharashtra.
are,
Lord, I've got, sorry.
sir, even in post-independent India, legislations had to be made in order to
Yeah,
deprecate elevation of sati to a pious religious act.
Yes.
So to turn our eyes away from
No.
that
What I'm submitting
reality
is
may
that,
not be done.
Lord, I'll leave
But
the
there in
part.
the 80s, in Rajasthan case, there was a
But
case.
I just got a message from an author saying that.
To make a monument out of it.
Correct,
The
correct.
place where she committed such.
Yeah. Lord, I'll not, but that's a very sensitive no time.
You wanted to help us on understanding
Yeah, moral.
constitutional morality.
Yes. Lord, to answer my Lord Justice Bakchi's point, Lordship will kindly see 25(2). I am saying that what it consists of two parts. It consists of parts where nothing in this article shall affect the operation of any existing law. Now, law in 25, in my humble submission, must be read as defined in 13(3). And 13(3) refers to
Submission, giving an expensive definition disjunctively from the remainder of the section.
no. What I was trying to suggest was no.
Qatar, that situation may not arise,
Yes.
as my brother has put it. Now, subsection 2 is an enabling provision,
Yes.
as we understood all of us. And A deals with certain where secular activities. B is on a social welfare and reform. So, the custom or practice, what you are saying, it is something which will be taking away the right given the 25(1) or akin to something else.
Exactly.
So, it is not something in support of the person, the good persons. In a law, when you say about the enabling provision, it only presupposes a similar act. It may not be a law, but supposing there is a practice which is contrary to the belief, touching upon economical, political, and which is similar to the area covered under 25A or 25B. Only to that extent, not with the custom which is supporting the right given 21(1)A. It is not meant for that.
No. I'm putting it this way, Lordship is ultimately going to decide. Lordship will just see 25(1). When it says subject to public order, morality, and health, what does it mean? It means a legislative law because there is no such.
Itself has two parts. 25(2)
It is true.
itself has two components.
Two parts, past and
First part A pertains to saving the existing law.
Existing law.
Part 2 pertains to the
Reform.
power, enabling power of
Reform.
enacting
Reform.
new law.
So,
At the-
but I'm putting it this way.
Thereafter, the field is given. What are the area which,
Correct,
that is given.
Correct. What I'm
So,
submitting is,
It is only meant for the.
What is saved under existing
no, what I'm
law?
submitting is this. What is saved are whatever practice.
So therefore, on the face of it,
Definition of existing-
on the face of it, a custom will not come under this.
Yes.
On the face of it will not come under, because it's enabling power to, meant to restrict or limit the right given under 25(1).
I will make my,
Itself, yeah.
I'll make my submission.
And
I would
this is the
submit
Definition of existing law under
I think
366.
probably Mr. Datar only wants to say that
law.
what is saved in 13(2)
What
first
was
part,
practiced on 26 January 50 saved
such customs or usage or law which pass the muster of 13C.
13.3. 13.3.
That's the correct way.
That's the crux. And what I'm
Wrong in
submitting
that.
is that law can then be reformed by the state.
Because
Because
it will
13.
be existing law only when it passed that
Yes,
muster.
but Lord, what happens otherwise on 13.
Constitutionality.
Exactly, Lordship has got it.
Existing law is made by a authority,
No.
not custom.
That your Lordship will decide. According to me, that may not be a humble submission. Is
See the definition under 366(10).
please see, Lord, 36610.
There is a definition.
Lordship,
But there, that is troubling us.
no, please see the definition of.
Existing law is not enacted law. This is the
No, it
13th.
is
Kindly
a
see, Lord.
definition under the constitution.
Fortunately, this issue does not arise
Yes,
before us.
now Lordship will kindly see, please see the opening part. In this constitution, unless the context otherwise requires.
Redundant.
Unless the context otherwise requires. Existing law means any law, ordinance, bylaw, rule or regulation passed or made before the commencement of the constitution by any legislature, authority, person. This is used in the context of 372. 372 says, because of the adaptation of laws, orders, etc., all the laws made before the constitution came into force will continue. It's not necessary that the legislature must pass the law again.
Definition clause applies to the rest of the, then they would have used custom or usage also.
Lordship will kindly see.
25(2).
No, I'm saying here,
They have not used
no,
that.
I'm putting it this way, my lord. 36610 must be used in the context of 372. I'll make my submission, I'll stop, my lord. 25(2), the word law must be understood in 13.3 because 13.3 says for this part, when the constitution for this part, it includes custom and usage. Custom usage is not mentioned here, but
No,
that
no,
law
this
cannot
part.
be ignored.
It says in this article.
Huh?
It says in this article, not this
Where?
part. 13. 13.3 is in this part.
In this-
article.
Yes, but in this article
is
means
part?
law. No. 13 will say in this article means because the word law is used in 13.1 and 13.2. Now, what it says is,
But 366 is definition in this constitution.
no.
Yes.
Unless the context otherwise requires. So my submission is the law will include custom. My point is this. If the exclusion of women in a particular temple, if certain practices were prevalent, they are all protected. They don't ipso facto become invalid. The local legislature has to make a law and do it.
We note it down, but we find it difficult to accept it. But
Yes,
we note it down.
No.
Can we
Yes.
expand
No,
the
but-
definition of existing law to include custom and
No, but
usage?
what is the ultimate argument, Mr. Datar? Let's
Yes.
proceed
No,
further.
but my
Let's
submission
not
is
unnecessarily stuck
because,
here.
yes, Lordship will
So
just.
there is a difference
yeah.
of opinion on
No,
this.
Lordship will kindly come to, yes. The other point I'm making is under
I am
20.
personally inclined what you are saying is correct, this
Yes.
statement of law, but let us proceed further.
Yes. My lord, my humble submission is when 25(1) says public health, public order, health and morality, what does that mean? It means laws made for promotion of public order, laws made for health, laws made for morality. So it means ordinary legislation for public order, health and morality. That's the first part of 25(1). Second part is provisions of part 3. So your right to practice profligate religion is subject to legislative limitations and constitutional limitations. Lordship gets that. Now the constitutional limitation came only in 26 January. That's why I said what 25(2) does is, because when we say morality, why it can't include constitutional morality? Because the morality mentioned there is a legislative law which curtails moral practice. So morality cannot be included there. So my submission is 25(1) has a legislative component, has a constitutional component. Restrictions on health, order and morality must be legislative restrictions, can't be a constitutional
We
morality.
understand.
Number one. Next
Yeah.
point,
Keep us understood better.
19.2 and 19.4, Lordship will kindly see, apart from 25, morality is used in 19.2 and 19.4. High courts have consistently held morality means social morality. It also can't be that they use morality as constitutional morality in 25 and use it with some other morality. So,
They say decency or morality.
yes, now my lord, I'll come to this. So my first submission is nothing in the debates. Second thing is, on the day constitution came, intention was to save customs and usages having the force of law, which were accepted. Now kindly come to Travancore Act. Please see my submissions. In 1950, now we are talking about 25(2)(b), making social welfare laws. Please come to page. Okay, fine. Yeah. Yeah. Lord, I declare when I refer to Mahindra, what I mentioned was that this custom usage is recognized. I'm not going into the what the Kerala High Court recognized this custom. What I'm saying is 1950, this law recognized it. Kerala High Court recognized it. Is continuing this, whatever the practice was. Kindly come to page 10. I know that I'm reading.
We agree with your submission to the extent.
I'm saying that they women are not allowed.
There is no concept of constitutional morality in the custom. Therefore, there is no question of continuation thereafter, where the concept of constitutional morality is lacking.
Completely lacking. Number one. Now, please see the page 10 of the submissions in the Travancore Cochin Code. Women were excluded in 1950. Please see, come to page 10. Page 7 is the Travancore Cochin law. Come to page 10, appendix is the rules. And there, from 1950, women of certain age have been completely excluded. Please come to 6C. Now what I'm saying is, and now please come to page 12, rule 12. Restrictions as to entry and worship, which according to usage and custom apply to all classes of Hindu alike, shall continue to apply. Now what I'm submitting is, the legislature of Travancore Cochin, in its wisdom, when it threw open, now this law threw open entrance to all public, all sections of Hindus. In the rule, they make an exception that whereby custom usage, women of a particular category are not allowed, that restriction will continue. Rule 12 also says that. So what I'm submitting is, even when they made a law with regard to social welfare and reform, they respected that particular practice. For a particular temple, if this is a practice, it should be allowed to be continued. Now I'm submitting the 1965.
Date of this enactment?
25th November 1950. Please come to.
November.
Yeah, please come to page 7. Sorry, the date is given.
April.
Yes, at page 9, published in the Gazette Extraordinary, 25th November 1950.
Rule 15 also slightly relevant.
Yes, Rule 15.
Maybe,
I'm grateful.
Maybe very slightly.
No one shall do any act which tend to derogate from the purity and cleanliness of the temple and its purity. The purity will also include the
12 also.
12 I read, my lord. Restriction as to entry and worship according to usage and custom or other demonstration would derogate from solemnity and sense. Now, my lord, my submission is, so the word morality should not include constitutional morality. I would recommend lordship may see para 176.7 Justice Nariman's judgment in the 5-judge case, where his lordship recognizes morality is a very difficult word to define.
Can't include this 15 from the point of view of purity insofar as women are concerned.
No.
They will come under C.
No.
They'll come under 6C and 12.
6C, not under.
12 also. Restrictions as to entry and worship. This could be some other entries.
Not 15.
Purity is only general.
Yes. Now, my lord.
Gender neutral.
Yes.
Now, the next, so second point I'm making is, as per the constitutional provisions, both 16.5 and 25.1 protect existing custom usage. It is left to the legislature to make changes as and when they occur. Now, next point on second point on constitutional, third point. Now, the word morality is what the legislature thinks. For each state will make different laws. Each state may have its own variations. I examined the word morality. In SCC online, if your lordship makes a word of search on morality, it is used in 66 statutes. 9 are pre-independence, 57 are post-independence. And majority of them used in the context of, in my earlier submission, I've given a complete chart. They're in 13 different categories. Public decency and, Lordship mentioned decency and morality, health and morality. Patents Act said you can't grant a patent which would be contrary to law or morality. Trademark says you can't register a mark which is contrary to law and morality, pre-independence laws. Succession Act, you can't make a bequest which is contrary to morality. So these are all things used. So all these people have used morality in the sense of social morality and not constitutional morality. So nothing in the debate, our article all protected. Thirdly, the march of law of lordship sees from the beginning till now, the word morality is used all the legislations, nothing to do with the concept of constitutional morality. Finally, I'll come to Justice Amanula's question, why we should not use constitutional morality. Lordship sees, my lord, from what research I did, it is used by Justice Jagan Mohan Das in the Kesan Bharati case in a different context on constitutional morality. Up to 2016-17, it was hardly used. Then there is a sudden spurt of constitutional morality, and now it's used in 79 judgments, including foreign exchange, decency, same-sex, privacy. Across the spectrum, morality is used. In fact, they say, the Noel Harper says, protecting, preserving foreign exchange is part of constitutional morality. So my humble request is, the essential principle of law, because I'm saying it is used in various ways, so it has got no concrete meaning. Whereas basic structure has got now derived a meaning, arbitrariness has got a meaning, privacy has got a meaning. These are all things. The other important point is, you must be able to peg a concept related to one article somewhere. Now, constitutional morality is such a nebulous term, you can't locate it anywhere. Privacy can go to 21, manifest arbitrariness can go to 14, and so on. But morality is a completely nebulous term. The last submission I'm making is an interpretation which promotes predictability and certainty must be preferred to something which leads to uncertainty and unpredictability. Once it's constitutional morality, and there are 79 judgments taking multiple different views used in different contexts, it will be dangerous to add constitutional morality, because as a 9-judge bench, unless your lordships clarifies that morality, like public order and health, is legislative morality, what legislature thinks it to be moral, subject of course to judicial review by your lordship, that alone should be confined. Let us not bring in constitution in the first part, because 25 has 3 components which are legislative and part 3 which is constitutional. Don't bring constitutional in the first part also. Let that be left to the laws. Finally, I'll submit, my lord, from the time the assembly started in 1946 till 2026, barring this one judgment, nobody has thought of including morality into constitutional morality. Lord, I have not gone into various aspects, but if your lordship sees, my lord, Mr. Rodgi mentioned about the judgment being lengthy and so on. What happens is, in different judgments, it is used in different terms. Even morality is used by Justice Deepak Mishra and Khanvilkar, Justice Nariman, Justice Chandrachud Malhotra. I have made a summary of it, and I would submit that Justice Nariman's thing, please see my note. That could be the proper interpretation of, please see first page of my note, para 176.7. After noting that it is difficult to define, his lordship holds that the correct definition of morality is conduct which is abhorrent to civilized society, given the mores of time by reason of harm caused by way of inter alia, exploitation or degradation. That could be a useful definition rather than keeping a nebulous term of morality. One more point of the lordship permission. One other point, my lord, will clarify as a tax lawyer. The court has held that the idol is a juristic person. Sorry, my lord.
The moment I saw this, I could make out it is by a tax lawyer. Yeah, Janet Duncan.
Yes. No, my lord, what I said was, I'm grateful. In my note, I mentioned many words are used in the constitution which are not defined. My lady mentioned 366.10. Sale is not defined, export is not defined, import is not defined. So what Gannon Dunkley says is, if a word is not defined when the constitution came into force, nomen juris. How it's understood in either General Laws Act or how it is understood jurisprudentially.
General Clauses Act, barring 372.
Yes. Yes. Now, my lord, on idle as a juristic person, last point I'll clarify. In para 405, page 5, lordship will come to my note at page 5. This may require clarification. The Honorable Supreme Court says, idle is a juristic person it can hold property, but it is not entitled to part 3 rights. That is seriously problematic because if I'm a juristic person, why should I be denied provisions of the Constitution where they use word person? A company is a juristic person. Company has got 14 rights. Wherever person is using the Constitution, he should get the right. Similarly, a idle, once it's a juristic person, you can't say it's entitled to part 3. And one more flaw is there.
In a jocular way,
Yes.
how would you interpret 21 with Pran Pratishtha?
Yes, 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 yes. Grateful. Not only that, in another jocular way, suppose tomorrow you pass a law differentiating
14 is a
between
very,
temples,
very-
can I not file a writ under Article 14?
The 14 is a very compelling argument.
Yes, yes.
There it is.
Yes, because there's a juristic person. If acquisition of property takes place,
Yes.
the assets of the juristic person cannot be discriminated unfairly.
And my lord, if your lordship's permission, Article 31 was a fundamental right
Fundamental
till
right.
1976, till the 44th Amendment.
Your point's very well taken. Just
Yes.
I wanted to make an interjection very jocular,
So
21.
my humble submission is, even in this M. Siddiq case, the Ayodhya case, they have made very extensive definition of this thing. And one thing I wanted to mention, last point, Bhashyam, Lords, please see page 5 of my
Article
judgment.
19 is only for citizens.
19 is,
Some other articles like 20, 21,
No,
14, they are for
no, in
persons.
fact, 15 is citizen, 16 is citizen, 19 is citizen.
But
Lordship is right.
14, 20, 21 are for
All
persons.
persons, 22 for persons, yes. Now, Lord,
Even 25 is citizen.
pardon me?
Even 25 it is citizen.
No, person.
Person.
Person, sir.
Person,
Then means, yeah.
yes. No, in fact, another problem is,
Yes.
just Nariman mentions, person will be only natural person. That also may not be
Right
correct.
compared.
Because wherever Constitution wants to use person, it includes juristic person. And when it wants to use a natural person, it says citizen.
Basically, it's for
14,
natural
14,
persons,
maybe
not for
14 and other
juristic.
14 is
Now you are
very
saying that
illustrative.
the idol will have a conscience.
Which one?
Will the idol have a conscience?
That's a matter of belief, my lord.
Because you say persons means in
Why not?
idol and
Certain
has.
rights, certain fundamental rights they can say. We can.
No, I'm saying to say that idol will not get part 3 rights as a general position may not be correct. Once you hold it's a juristic person, then logically, all where a person is, they'll be entitled to the right. And lordship will kindly
So
see.
that is what you intending to say contextually consider the word person in relation to the idol.
No, my lord, my humble submission is
Contextually, we will have to read in the part.
not only that, this question of whether the idol as part 3 was never in consideration in Sabarimala. Suddenly they say not entitled to whole part 3 rights. But Article 31 was there. That was a fundamental, was a part 3 right. And it has large
That
ramifications
may not
across
be
the law.
required for us to decide.
That may
In
not
this-
be
Yeah.
That might have,
Yeah.
create more problem there.
Therefore, my lord, my humble submission is I'm confined myself to constitutional morality. I'm grateful.
Thank you, Mr. Dutta. Yes, Mr. Super.
relevant for that case.
Pardon me?
NSS is not
No, my friend wants, I'm appearing for Nair Society. We are supporting the current practice. We are for the review petitioners. We are supporting the things. What I'm telling. Yes.
We are not millets. The NSCC is not supporting the entry of human millets.
Yes, that's what I'm supporting. Yeah.
Newspaper entire will come out with something else tomorrow.
He wants to declare me hostile. I'm not. No, in a lighter, I wanted to say that since I quoted the Kerala judgment, I only wanted to say Travancore Cochin 1950 upheld it, the Kerala High Court upheld it, 65 Act upheld it. Everyone has, yes. So,
What is struck down?
and one more thing, that practice has continued. My lordship will kindly say, I stay in Chennai. My lord will know that, and this whole Ayappa thing has picked up in the last 30-35 years. And lordship has to see the devotion is on a different level. They genuinely believe that.
Up to 96 Kerala judgment, it was only writ petition directly entertained in this court.
Pardon me?
Yes, yes.
After the 1996 Kerala judgment, which was not challenged probably,
Yes. 93.
that in a way attained finality there. After that, only a writ petition came in this court in
Yes,
2006.
Exactly. So I'm only submitting that. Yes, and one more thing I'll mention to lordship.
Was there a challenge to Rule 3B?
Where?
In the restriction, they challenged Rule 3B.
Yeah, in this, yes, in the Sabarimala, yes. It has been struck down.
Before
65.
the division bench of the Kerala High Court.
Pardon
Before
me?
the Kerala High Court.
No, Kerala High Court of the PIL started. Yeah.
Kerala High Court
This is
was
a
challenged.
direct.
It was a suo moto case. It was a suo moto case.
Rule 3B was struck down. Was it challenged?
It was a letter which was taken as a PAL.
PIL, it was the PIL.
Letter was taken as a PAL.
but then your lordship may record that we are supporting the current practice of
Rule
women
was
not being allowed, lordship may record that, right? Yes. So, we,
That issue was considered and the rule was found unfounded.
Was there a pleading or nothing?
no, the rule permitted them.
No. Rule did not permit.
Oh, this is the letter.
And therefore,
Let's say letter OP, letter OP.
It was virtually a suo moto writ petition.
All right. Yes, Mr. Shamsad.
A letter was addressed to the Chief Justice that was taken as a writ petition, PA.
I'll just read the first part. This is a public interest litigation. It has, sorry. But we are not on that. I just wanted to say that at no point of time, this practice has been sanctified and accepted throughout. Yes, that's the whole point. And you can't have one law which applies across the nation. Each state has got its own peculiarities, and that has to be respected.
And my lord, before referring to the 5 judges, 3 honorable judges discussed in detail whether SLP should be filed or a 32 petition should be filed. And there was a serious deliberations and discussion. Ultimately then referred to the 5 judges. So SLP was the proper. As my lord yesterday observed, they should have filed an SLP. Then there was a delay.
In 96 judgment.
93.
I'll just read the conclusion.
The basic issue of not restriction of entity was not discussed at all. Because there are 18 holy steps. So each and every based on it is considered as one is anus nose like that.
Anyway, that is now only a history for correction of facts. That's all.
One second. Para 44 is the conclusion.
Please get.
It's not a civil right. It's an absolute property belongs to the deity. In all the countries, record that property of the deity. So they must go property. So when deity has yes, I decided not to enter my property. That was decided because they think that called day of person. In all day of person, event secretary was restricted.
And
No, it's age regulation.
no, I'll just read para 44. I'll just read para 44 and I'll conclude. One second. Yes, interesting story. He's waiting for him.
Menstruation is celebrated. In every month, menstruation happens in that, but in Kamakya also.
Yes.
My lord of 5 judges, 3 honorable judges did not consider even menstruation or menstruation.
Lord, I'll just read the conclusion.
It is in our favor.
One second.
We are against that argument. 3 honorable judges say so. We are not considering menstruation.
Let him complete.
I'll just read the concluding part. I'll just read the concluding part. Para 44, our conclusions are as follows. The restriction imposed on women aged above 10 and below 50 from trekking the holy hills of Sabarimala and offering worship is in accordance with the usage prevalent from time immemorial. Such restriction imposed by the Devaswam board is not violative of 15, 25 and 26. Such restriction is not violative of the provision Hindu place of worship, entry act 16, since there is no etc. etc. That's been fully sanctioned.
Your lordship, please.
Thank you.
Whatever time today is left, my lord, because even if your lordship sits 20 minutes beyond, I'll not be able to finish. So I'll start today, my lord, now.
There are other also.
Yes. Yes. Lord, I had initially filed my written submissions, but I have reduced it to 6 pages.
Which volume? Which volume? No, now he is filing revised one. I think that's a very good thing most of you are doing. Depending upon the arguments which have already taken place, most of you are now filing revised. That's a good
Yes,
practice.
madam. Yes, madam.
That we appreciate because instead of repetition of.
Again and again.
Yes. What I have done also here, I found about 19 cases which your lordships from Shirur Math till now, which I found to be relevant. I have made a chart. And that chart gives that what all were before the court, whether it was a state action, it was without a state action. So there is a detailed chart of 19 judgments. In addition to my notes of 6 pages, my lord. My lord, in my submissions, my lord, I'll not touch all the points. I'll touch only 2 issues here. But before that, before I come to those 2 points,
Sir, just
My lord.
I'm interrupting you for a second.
my lord,
All those young lawyers who want to make submissions, just note down your names and the minutes or second you need. Nothing like half an hour, no question. You will tell us only in minutes and single digit. In single digit minutes, note down your names on the piece of paper without disturbing us. We are hearing Mr. Sumshar, don't disturb us, but write down on a piece of paper. Now, yes, Mr. Sumshar.
so my lord, before I come to my submissions, where I have given points of submissions only 2, which I will come little later, my lord. I am respondent number 7 in
In
point
472.
0.66. That is the writ petition filed by one Yasmin Zubair Pirzadeh. And also, the same person is also an intervener in the main matter. So, the common arguments, my lord.
The petitioner.
Yes. That petition, my lord, with respect, my lord.
We'll hear you on this side then.
That petition, my lord, after this matter was filed and first judgment was passed, during that time, this petition came to be filed, that why Muslim women should not be allowed to enter into mosque. Enter into mosque. The petition is saying that they are PIL petitioner, so they are saying that I have written letter to particular mosque and they said that we have no provision. So that is the background. And the scheme of the petition is that my article 14, 15, 19, 25, up to 25 is violated. There is no mention of 26. So I'll not submit in details on denomination, my lord. Probably one of the dargah is here, Mr. Pasha is representing. So the petition, my lord, I just wanted to place it before your lordship because in the petition, the prayer is of such a nature that women should be permitted to stand in the first row. Women should be permitted to stand in the same line. So this is the scheme of the petition. Now in this background, my lord, because at some place they also tried to give an inference as if inside the mosque there is some place which is equivalent to sanctum sanctorum. Sanctum sanctorum has no place in mosque. That, your lordship, I wanted to clarify. Because if that is the case, this petition, my lord, substantially has no locus. Because if the religion believes that there is no sanctum sanctorum inside the mosque, then nobody can insist that I have to stand at a particular place, or I have to, for that matter, even I have to be first to lead the namaz.
Just for factual clarity.
My lord.
What is the factual position? I mean, women are allowed, but allowed to search.
I have given an affidavit, detailed affidavit. There is no quarrel across the religious denominations in Muslims that women cannot enter into mosque. And that too for prayer. They can enter into mosque. There are certain discipline that has to be followed. So
I was emphasizing for the reason because the prayer itself is saying that sorry, I will not follow that.
No, Mr. Shamshad, you should, at this very point, you should elaborate for everybody's consumption that right from the beginning, there's also no dispute that it started from the Holy Prophet himself.
Yes, madam. Yes, madam.
There's absolutely no difference
There is-
whether it was
I will
later
come-
developed, whether it, you have to start that with the.
I will come to, because I was,
The book.
my lord,
You have to start from that.
I'm so obliged, my lord. Prophet Muhammad himself said that don't stop women coming to mosque. So there is a clarity on this, and many of those who have recorded the hadith, which are in many, there are many volumes written by many authors. They have recorded this narration, and this is authentic, that Prophet instructed that don't stop women from coming to mosque. But at the same time, there is consensus amongst all the religious denomination amongst Muslims that it is not essential for women to be part of congregation to offer namaz. So there is,
Namaz there.
yes, so there is hadith on this, that a woman is free, preferably at home, to offer namaz, because if some believer of Islam has to offer namaz, it is obligatory upon him for 5 times namaz to be part of the congregation. There are certain exceptions. But as far as men's position is concerned, it is obligatory upon him to be part of the congregation. For that, you need mosque. For women, it is preferable that she stays at home and she gets the same religious reward which the man gets in mosque. But at the same time, if woman wants to come to mosque. Don't stop him. And when this petition came, my lord, we filed an affidavit saying that, I can read it, that considering the religious text, doctrine, religious beliefs of the followers of Islam, it is submitted that entry of women in mosque for offering prayer, namaz inside the mosque is permitted. I have explained there are certain discipline that has to be followed.
Except that they cannot be part of the congregation when.
Part of the congregation, part of the congregation.
Except.
No, they can't.
No, they can be. Yes. They will be part of the congregation.
They can be.
Yes. If they are going to mosque, the purpose is to participate in congregation, and that is permitted.
But it is not mandatory for them to attend a congregation.
Yes. It is not mandated. Rather, it is preferable, which I have already said, that they can stay at home for.
Stay at home and pray there.
Yes.
Give the reason also. The reason was that if everybody goes from the house, who looks after the children from their house?
My lord.
So preferably because she takes care, all the reward she gets. If she gets the time, if she has the capacity, he can also go. But then the difference comes. Now the crux comes. Whether she will stand at the first,
Yes.
these are all managed by tradition, right from the Prophet's time himself.
Yes, my lord.
So
So
absolutely no.
I'm so grateful, your lordship, as
No interaction. No interjection. Kindly take your seat.
The way to interrupt.
my lord, because the scheme of the petition, there's sanctum sanctorum, and that's why I have to be everywhere, wherever I want. The sanctum sanctorum, there could be 2 situations in which it can be imagined. One is the holy place at Kaaba, where there is a place, and everybody has to take a round. And there, because the situation is such, you can't stop, so they can mix up, they can do it together. That principle is introduced in mosque everywhere in the world. That is not acceptable, my lord. Second situation is of Dargah, where there could be some sanctum sanctorum.
Petition.
My lord, I'll read it. It is very interesting.
Prayer.
Don't interrupt me.
What is the prayer?
The first prayer is, because first, second is little different, but third, fourth is very, issue writ order. So your lordship will issue writ that they should go. Direction, nature, mandamus, all respondent permitting the Muslim women to other mosques, inter mosques. Second, issue writ order direction in the nature of mandamus to all the respondents permitting Muslim women to offer prayer namaz inside the mosque. Not a problem. These two are not a problem. We gave affidavit. Issue order direction in the nature of mandamus permitting Islamic women to enter through main door, have an Islamic right to visual and auditory access to musalla within bracket main sanctuary. So that's why I said that they are trying to bring in sanctum sanctorum concept inside the mosque. My lord, we come from villages, and in the villages, when there is when the inside it is too hot, then Imam himself will come out in the courtyard, open courtyard, and the entire mosque is vacant, and he will lead the prayer. We'll stand behind him. So within the mosque, there is no concept of first line or sanctum sanctorum. Fourth is issue writ order or direction in the nature of mandamus permitting women to pray in the musalla without being separated by barrier, including the front and in mixed gender congregational lines.
I think this appears to be the real.
Both
filing reputation.
issue appropriate writ certiorari direction, setting aside direction fatwa restraining Muslim to enter. And then they say that declare unconstitutional violative article 14, 15, 21, 25, 29 of the Constitution. So 26 is missing here. So this is the scheme of the petition, my lord. In view of the affidavit, my lord, prayer A and prayer B has no problem, but these prayers, my lord, with respect, this is court of reference, my lord. Whenever it goes back, these prayer will have to be rejected, my lord. And so this is the first part of my submissions. Second part, my lord, in the point of submissions, my lord, your lordship may see, I have some additional reasons with perspective to say that ERP, essential religious practice, is problematic. It has been argued with certain perspective. So I will add to it how. And second is, my lord, that Article 25(1) has two terms. One is subject to and one is entitled to. So I'll try explaining in whatever way I could what is the meaning of entitled to, equally entitled to, and the first subject to, where the burden goes. Whether if some law is made under public health, morality, etc., who will have this burden to prove that whether it is violating my practice of religion, whether a state has to prove it, or the person who is aggrieved who has to prove it. So I'll come to that, my lord. As far as the first submission is concerned, my lord, that ERP, essential religious practice, my lord, Dr. Dhawan, whom I have assisted in many matters, my lord, and I have learned from him, has elaborately argued generally why essential religious practice, my lord, is not a good concept. Even Mr. Dwivedi argued. I adopt these submissions, but it has to be seen in my perspective, which I am going to submit, my lord. I'm not reading this because this Shirur Mutt says that what constitutes essential religious practice is primarily to be ascertained with reference of doctrine of religion. Second, it says that all matters of religion within the meaning of Article 26, after citing example, and then religious denomination enjoys complete autonomy in the matter of deciding rituals. No outside authority has any jurisdiction. On the other hand, your lordship, on the second page, in Tilkayat, my lord, your lordship say we also have a position that the question will always have to be decided by the court. So there is, earlier it was something else. Now it is that it will have to be decided by the court. In Dargah committee, my lord, the indication is that integrality and essentiality will have to be decided by the court. I did not find that much clarity as it has come in Tilkayat. And in Tilkayat, I remember there is a place where court again says that when communities speak in different languages, then the court will have to decide. With respect, my lord, this has to go. On coming to the submissions of ERP, my lord, in the context of Islamic law, Islam is a very heavily and very thoroughly written religion and rules what can be done, what cannot be done is written in lot of details. Volumes after volumes have been written. It is not only the primary source, that is the Holy Quran, has to be seen to understand the religion. My Lord Justice Mahadevan pointed out one scholar, Zakaria Navvi.
Abu Zakaria.
Abu Zakaria Navvi.
Related to Riyalus Sologan.
My Lord, there's 2 volumes and he died at the age of 45 and he wrote 10-15 books and those books are considered even today authentic and so relevant. Similarly, my Lord, Ghazali, who challenged the Western philosophy through Islam, he died at the age of 44, 45 and he wrote volumes and volumes. And then I remember Justice Dattu in his farewell saying that every lawyer must read Rumi. So these are, I'm not talking about hadith right now, hadith, books of hadith, which is, there are four, 5 set of books of hadith. So these, this is how the Islamic context, Islamic texts are recorded at different places. Now coming to this, my lord, page 2, this is Roman 3. The classification of different mandates in Quran for determination of ERP, my lord. Different mandates in Quran from the commandments. Generally, the commandments are imperative. Before I go there, my lord Justice Nariman has noted from Justice Hidayatullah. This is volume 5, page 492. 5.5, page 492 in the judgment section. But in this table also, my lord, I have quoted that portion, which I would want to read, my lord. This is at page 23, item 18. If your lordships have 4th column, lordship has 4th column. Indeed, this is item 18. Indeed, 4th column, Islam divides all human action into 5 kinds, as has been stated by Justice Hidayatullah in his introduction to Mullah. This is first is degree of obedience. Islam divides all action into 5 kinds, which figure differently in the sight of God and in respect of which his commands are different. This plays an important part in the lives of Muslims. First degree, that's first. Even in whatever is commanded in Quran, Hadith, Ijma, must be obeyed. So this is the first degree. And here it is not only Quran, because many judgments, your lordship will find, the honorable judges have tried finding what is written in Quran, and if it is not there, you get out. And that's the grievance, my lord. whatever is commanded in Quran, Hadith, Ijma must be obeyed. So there are four different sources through which the commandments have to be ascertained whether it is farz or not. Second is, my lord,
Wajib also perhaps a little.
yes, wajib is part of farz, perhaps a little less compulsory than farz, but only slightly less or so. There are many schools, my lord, which consider farz and wajib together. For example, I was talking with some Shia scholar. They said that we don't categorize wajib differently. So for everything we have farz. But there is, which India follows largely, Imam Abu Hanifa of Hanafi school. So he gave this principle that within farz there is some category, but for this, my lord, both can be taken together, farz and wajib. But there is some issue with this, but largely this summation of Justice Hidayatullah is correct, except one which I will point out how this is not, there is some error in it. Third is jaiz, which is, second. Second degree is masnoon, manzoob, and mustahab. These are recommended actions. Third is jaiz mubah. These are permissible action as to which religion is indifferent. Fourth, makruh. That is that which is prohibited, reprobated as unworthy, means that you are discouraged, don't do it. But if still you do it, there is no sin in that sense. Like there are certain practices which we do, but that fall into makruh. But we fifth is, my lord, haram, which is completely prohibited. So this is the first one and second one, last one, both are important. My reading is, my lord, that essentiality is not only in the first degree, essentiality is also in the last degree, because if something is completely prohibited, my lord, I will come to that 25(2)(a). If there is some legislation, there is somebody facing FIR that why you are saying that I will only eat halal. It's part of Quran, it is part of Ijma, it is part of Hadith everywhere, that it is completely prohibited. So essentially forbidden. So the essentiality in Islam will have two facets. One that you must do and other which you must not do. So when the courts are examining these issues, till now, my lord, the trend is, we were going through all the cases, my lord, except once. All the tests of ERP, as far as Islam is concerned, have failed in Indian courts. And that's a serious concern for us. That except Sayyidina, my lord, whenever the matter has gone to the court has tried looking into the Holy Quran, said that if it is not found, go. Somebody says, some scholar says that sorry, Sunnah is practices of Prophet, so it can't be essential. That is completely wrong understanding. Quran itself says, thank you, obey the Prophet, and what Prophet said were written in books of Hadith, and his companions narrated it. And my lord, it's very interesting that those narrations were contemporaneously recorded, but some were oral, some were recorded. But when these books were compiled, a very rigorous exercise were undertaken. And those exercises included, my lord.
So, Mr. Shamsad, here you should clarify.
My lord.
Here you should clarify that the hadith is not only what the Prophet said. For following Quran itself, hadith is needed, because in the Quran it is said, pray to God.
My lord.
Now, what the prayer would be, what time, it has to be the treatise.
My lord.
Like the Agamas and all, how you worship. It's same as that. So what is not there, The Quran only tells, do this, do this. How to do it, the practicality is there.
His prophet
So it is-
showed
it is an
and which was
extension.
recorded. I'm so obliged.
Without that, the religion itself cannot be followed.
It cannot be followed. For example,
There are groups
the,
where
the
it is
basic issue of offering namaz 5 times, you can take it from the holy book that Salah is noted in the Holy Quran. What was the timing? The Prophet offered particular namaz at particular time, sometime 10 minutes before, sometime 20 minutes later, but it was within that time range. So some school follows the first time, some school follows the last time. So that is the only difference. But as far as in the morning, one namaz has to be offered.
Be very pointed, because otherwise we're going to be very pointed. You say that those different school of thoughts relate to things which the Prophet himself did.
My lord,
But there were variations because there was dynamism.
my lord.
He gave the option that if you are traveling, so you could postpone it to later. So some school of thought go for that dynamism and they have their brand. Otherwise, there's no dichotomy or no difference in that.
My lord
This
has
is how
articulated in a
came up.
better way, my lord. Lordship has.
Be very point. Otherwise, we'll keep
Yes.
on moving from here to there.
Yes, madam. I am so obliged, madam. So the second is B, which is which commandment in Hadith is to be read to determine the practice of farz wajib shall have to be first determined in by. I am coming on the issue how it is done, how this exercise has been undertaken by classifying the Hadith recorded in different books of Hadith. Prior to that, it is necessary to undertake the technical scrutiny of narrations. The scrutiny is based on the continuity of chain. For example, somebody was sitting with him, with the Prophet, or he has seen, but the person who has recorded was not there. Later on, he wanted to record, so he met that person. And if that person was not there, then he went to another person. So this chain was first ascertained that it leads to the practices that Prophet followed. Integrity of the narrators. Precision, absence of hidden defect, while undertaking the exercise of linguistic structure to be determined. So this is the process through which how from Hadith a necessary or essential commandment can be culled out, which has been done by the scholars. C, linguistic structure, which includes intertextual reconciliation, harmonization, preference, and abrogation. This, my lord, I am not reading it. I'm just, I will explain it. The main book from which can be of Mullah in Islam, of Muslim law, has largely relied upon a book called Hidayah. For Muslim personal law, which is practiced in India. It has been recorded from Hidayah. Hidayah was originally written in Arabic. And thereafter it was translated by somebody in Persian. This Imam Ghazali was from Persia. Somebody translated into Persian. And when Britishers came to India in 18th century, when they were taking over courts, etc., they needed a book. So he commissioned one Mr. Charles Hamilton to translate Hidayah into English so that they have ready-made English code. This Arabic translation to Persian and now Persian to English. Mr. Hamilton did not know the language of Arabic. Here is the problem. Here is the problem. I said, because I will come to this, Justice Hidayatullah's first degree farz, whatever is commanded in Quran, probably to this extent is some error into it. It may not have been committed by Justice Hidayatullah, not by Justice Nariman, because he has quoted. Because it is translation after translation. Now, for example, I have given few examples, my lord. In page 3E, page 3E, this is A, small a, my lord. Quran commands that if you are entering into business transaction, record it. This is in the nature of commandment. But reading the entire sequence, seeing the Prophet's lifestyle and doing transaction, the scholars have reached a conclusion that it cannot be put in the category of farz, that it must be written. If it must be written, then the transaction will become void. So there are few circumstances in which the scholars have decided with consensus that despite there being language of commandment, it may not be essential. And there is converse also, where there is the commandment is not there in Quran, but later on, seeing the Prophet's life, seeing the narration in Hadith, and I'll come to Ijma, the scholars have decided that this is in the nature of farz and mandatory commandment. So these are two different things. And that example is, my lord, I have given at C. This is, for example, allocating 1/6 share of inheritance to paternal grandmother in case of predeceased grandson. If grandson dies and grandmother is still alive, in Quran itself, there is the entire details how the inheritance has to take place. But grandmother's was missing. Now, despite it not being there in Quran, there is ijma on this. Ijma is general consensus of the scholars. Through interpretation, through analogy, through by applying different modes. So it has been declared and accepted that grandmother will have 1/6 share, irrespective of missing commandment in Holy Quran. So these are I'm coming back, my lord, and that's why the linguistic structure and Charles Hamilton I was placing before your lordship. This I have noted. I may not read it because it will further.
Your argument appears to be, Mr. Shamsar,
My lord,
that the script which is originally in Arabian, then translated into Persian, and from there to English. These all three have been studied by different scholars, and these scholars have summed up their conclusions, which are believed to be the principles laid down by Prophet Muhammad. Some are mandatory in nature to be performed, some are mandatory in nature prohibited.
one of the arguments, my lord. One of the arguments, your lordship has correctly understood, but it is
And therefore, all these mandatory positive action or mandatory negative action, prohibition, are the belief within the ambit of 25(1) and duly protected.
yes. So now I have explained how, and I have also said that,
That does sum up.
Yeah.
Exactly, beautifully it has been summed up.
my lord.
Honorable the Chief Justice has beautifully summed up the crux of the focus of the. Exactly.
My lord. So, my respectful submission is that when a matter comes before this honorable court, that certain practice should not be permitted because this is non-essential, or somebody comes to enforce his right that it is essential, it is not that you just look at translation of somebody of one book and take a decision. For that, with respect, my lord, I would say that considering the material, considering the text available, and the scholarly efforts that has been undertaken in so many years, my lord, the courts may not get into this, that I will say that, sorry, this is wrong. One of the parameter to determine whether it is essential or not is also the fact that something is commanded in original text, continuous practice with diligence and sincerity and bona fide, with Dr. Dhawan said, bona fide issue. It's very important. I took it from there. My lord, there may not be few things. For example, my learned friend will appear for Dargah. It is not practice of 50 years. When it goes to the court and somebody will say that, sorry, you get out. It's not essential. If it has continued since long and it has been bona fidely practiced and there is no mala fide attached, this practice also by scholars
Will be protected.
have been placed in the category of furs, which is essential. So that is the summary of
Moment
it.
it is a religious practice, it becomes under religion and protection. Why do you have to go to essentiality and all? The moment it is a religious aspect, a religious facet,
My lord,
prove it to the last at least 1100, 1200 years, minimum 1200 years,
my lord,
it has maintained the continuity
my lord.
without any demur, without any change. And why to go to the essential, on the essentiality of it?
My lord, because the essentiality is the core issue here, which is under challenge, my lord. That's why I place. I'll leave it, my lord.
If you assist us, all your colleagues have also said that essentiality should not be gone into by the court.
Yes, my lord. Yes, my lord. Yes, my lord.
Yes, this is a written code to last more than 1200 years at least.
My lord.
1450 years ago, the Prophet died, but last 1200, more than 1200 years, the hadith is continuing in the same form.
My lord. My lord. So I have.
Without any demur or.
I have written this, that ijma, which your lordship will see at page 2 of this note D, which is essentially that what my lord Justice Amanullah is saying. Essential religious practice in Islam were also declared through ijma, which is consensus of ulama, in the initial 4 years of Islam. Now, thereafter, 400 years of Islam, it was applied in cases where Holy Quran has either indicated something without details or indications are found in authentic hadith, and to resolve serious differences which were found among different sections or were declared by general acceptance by companions of Prophet. So this Islamic history may be 1500 years old, but my Lord Justice Amanullah has rightly articulated 1100 years old practice has also been placed in the category of furs, which is mandatory. So this is, my lord, the sum and substance, that this is how this is done. The second aspect is, my lord, and in this, my lord, I want to place one case, my lord. This is Ismail Faruqi case, my lord. Ismail Faruqi case, Dr. Dhawan is here. He argued in 1994 this case. In that case, issue was not there whether it was essential or not. Masjid was essential or not. I asked Mr. Jilani what was the context. He said that since masjid was demolished, so Muslims claimed their right that I can offer namaz even in open. When the majority judgment came, my lord, Dr. Dhawan may correct me, he's here. When majority judgment came, it said that since namaz also can be offered in open, masjid is not essential. My lord, this parameter is completely wrong. And that has been applied without saying so in subsequent judgments. I was appearing in a case which I lost in Supreme Court, my lord, where a parking of a temple was to be extended and 200 years old mosque was demolished, acquired for extension of parking of temple. And that's where, my lord, Dr. Dhawan argued this before Honorable 3 judges for reconsideration of this matter by larger bench, and it was rejected by majority of 2. And the entire submissions of Dr. Dhawan is recorded in the minority judgment, my lord. So, my lord, there are instances where the plea of essential practice was not taken in that sense, as it has been decided. But still courts have gone and decided it. And that is coming on the way. But masjid for a Muslim, masjid is a spirit of Islam. Let me tell this. Masjid is core of the belief of Muslims. All the practices of Muslims are ultimately relatable to mosque. But when we face, my lord Ismail Faruqi, that masjid is not essential, then what do I do with Article 25? The Lordship will consider this.
It's as good as saying temple is not essential.
My lord, I wanted to add it by saying that if idol is...
Who is the court to determine that?
Exactly. That is the point. That is the point. Second instance came.
We understood that.
Second instance, one more instance, then I will not give more examples. There was a boy who wanted to have beard like Mr. Pasha has. And he wanted to join army. Army said, get lost. When the matter came before your lordship, the court asked learned senior counsel, tell me from your religion that this is mandatory for your continuing as Muslim. The learned senior counsel came back after some time. I have put it in the tabular chart, my lord.
The officer was terminated or
Terminated. Now, he came with certain text. It also depends, my lord. Mr. Pasha thinks that it is mandatory for him. I feel that I can be without it. I may not be a good Muslim.
I think let's not cite armies.
No, my lord, I will have to.
Armies, we have dealt with.
No, because I am saying because if my Sikh brother, can go and join army with beard, why can't a Muslim?
Please confine to
That is not the
This is my lord. This is the core of essentials being decided by the courts, my lord. With great respect.
Bear in mind Article 33 of the Constitution.
My lord.
Article 33 of the Constitution.
Article 30.
There is a restriction of fundamental right impact.
Yes, my lord.
In respect of
Parliament has a right.
I completely agree, my lord. I completely agree. The argument before that court in Zubair Corporal, which is the case I am talking, my lord, that, see, if for a Sikh,
the exception in the rules were applicable only to Sikhs
yes,
because it was essential to the Sikh.
if for a Sikh,
not seen as essential to
Sikh,
Islam.
it is all right. Why can't it be for a Muslim? So that way, my lord.
You see, we will not enter into this debate.
33.
Otherwise, I can point out in the Sikh religion, there are 5 basic principles which are mandatorily to be followed, and keeping beard is one of those principles. Therefore, we cannot compare other religion with Sikh religion for the purpose of keeping a kirpan, for the purpose of keeping
Kirpan
caste,
is
for the purpose of
Kirpan
keeping
is
beard. They have their mandatory religious principles that are every Sikh is required to follow.
I'll come to the next
That
point.
is the difference between the Sahajdari Sikhs and the true Sikhs. That controversy I have dealt with.
I'll not press it further, my lord. For us, he will always remain doctor, sir. Now, second point, my lord, I'll just try.
Yes, it is. You have earned it. It is not conferred, but you have earned it. Unlike conferred doctorates, honored doctorates.
Sir,
Mr. Samsad, 50 minutes already.
may I take?
How much time?
He will just
May I continue Tuesday for 15 minutes only, not more.
5 minutes.
My lord, that day because this
See,
subject too, and
it's not that the court is the last function.
So next day I'll take 10 minutes, my lord. 10 minutes only, or I'll not go.
Just sum up quickly.
My lord. This is page 4, my lord. This Roman 7, my lord. Article 25, this starts with subject to and equally entitled to. Now, because on other aspects, a lot of arguments have taken place. My submission is, my lord, subject to is for limiting certain aspects, certain aspects.
Where are you referring?
My lord, this page 4 of this note which I have submitted, my lord, 7, Roman 7. This subject to is a limitation which public order, health, morality, part 3, etc. My lord, this article, with greatest respect, my lord, in comparison to all the articles in part 3, is already weakest article, which I feel. There's so many subject to items.
It's a conditional fundamental right.
My lord,
Though other fundamental rights are also.
the petitioner which before your lordship has, he is pleading in the writ petition saying India is country built on foundation of a civilization that is fundamentally non-religious. This is what they have pleaded. I don't know. This is Keshwa, this S.R. Bomai, my lord. I have one page I have summarized at page 24. In view of this, page 24, my lord, S.R. Bomai. S.R. Bomai says freedom of faith and religion is an integral part of the social structure. So, not what is integral to religion.
That's why argument
is saying integral.
6 is also basic feature of the Constitution.
So,
that is the argument.
if it is so important, my lord, whenever your lordship is considering what is public order, how it can be, how the laws can be made under Article 25(2), your lordship will give some force to this right. In our country, my lord, it is so much of religiosity, so much of conviction towards religion, not only for one religion, it's across the board. There may be people who are atheist, but across the board, the religious affinity is everywhere. And everybody wants to go to temple who believes in that. Everybody wants to go to church, mosque, etc. So this Article 25 has to be given to some strength, my lord. Similarly, when Article 25(2), the secular law, etc., my lord, because your lordship has said 5 minutes, my lord, secularism is not only a legal issue. A lot of politics involved in secularism. So when your lordship is interpreting the Article 25(2)(a), even for that matter 2(b),
secular practice,
there has to be some parameter that on these grounds, whenever the parliament decides to make a law, it can be checked.
So, we should not never make a mistake of laying down a principle on hypothetical basis. It will be on case to case. Say tomorrow,
on case to case basis.
A law is enacted tomorrow. Then you are right. That law need to be tested on this.
My lord,
that does it meet with the proportionality doctrine? Does it meet with the parameters which are within 25(2) or 25(1)?
What happens?
And if you exceed that, then obviously
I'll close it in 2 minutes, my lord. Now, 2-3 minutes, my lord. What happens? When the law is made or executive regulation is made, it becomes matter of policy. And the presumption is that is correct. Now, when your lordship, the urban planning is done today, in urban planning, there is a rule that these many number of residents should be there to claim the land for religious places. Now, where the minorities will go? It is matter of legislative policy. So these are hidden defects that I am trying to point out. That your lordship will observe something, that this equally entitled to does not become victim to the majoritarian concept of lawmaking. The Solicitor General said that through majority will make law. Yes, he is right technically. Justice Amanullah's intervention was very relevant. That majority doesn't mean that you are not committing majoritarianism. Similarly, my lord, we were arguing this Waqf. When you take over the Waqf properties, the government comes in the command. In the ASI rules, there is a rule that during sunrise to sunset, because the provision is that the nature of building or the practices shall continue. So during sunrise to sunset, the nature of practice can continue. It may fit to one religion. When mosque is taken under ASI, 3 namaz is gone. Facially, it looks that it is very neutral, but it is not neutral. It is discriminatory. Like land allotment. It is discriminatory. That's why I am saying, my lord, that whenever this principle is going to be laid down, your lordship has done in Keshwananda Bharati basic structure, it will be struck down. Some principle, some reason, some basis will have to be given that when somebody comes with.
We appreciate that.
And lastly, it's very, my lord, in this petition, Mosque, somebody is before your lordship and I am on notice that for Muslim women to practice namaz, mosque is essential. And I have a judgment that mosque is not essential. The lordship will consider this. I respectfully submit, my lord, that this Ismail Faruqi concept, if your lordship feels
May I seek lordship's kind
something
permission?
has to be done in this.
May I
I'm
seek
so
lordship's
grateful.
kind permission?
Now, how much time you?
10 minutes, my lord. Tuesday morning, 10 minutes.
10 minutes.